Good afternoon, Chair.
Advocate Ngcukaitobi, we have not finished reading, but we have made progress. We are comfortable to start with your witness. I suppose that the evidence leaders also have had a chance to go through the statement. We propose that we pause after 1.5 hours to stretch our legs, reconvene, and do the same thing. We'll see how far we go, but we're going to need the comfort break from time to time. May I take this opportunity, Advocate Chauke, to administer the oath? You taking the oath or the affirmation?
I'll take the oath, Chair.
Thank you, sir. Do you swear that the evidence you are about to give will be the truth, nothing else but the truth? If so, raise up your right hand and say, "So help me God."
So help me God.
Thank you, Counsel.
Thank you, Madam Chair. Mr. Chauke, can we just start with the formalities? In front of you, you should have your witness statement that starts from page 1 to page 121.
Yes.
Is that correct?
Yes.
Okay, you've read it?
Indeed.
And you confirm that it is true and correct?
I confirm.
And that it is binding on your conscience?
Indeed, I confirm.
Yes, thank you. Now, you've obviously been listening to the case for or against you during the course of this inquiry, is that correct?
Yes.
Yes. And so you know the gist of the allegations against you?
Indeed.
Yes. Now, and you've looked at the terms of reference?
Yes.
Yes. In relation to the allegations that are made against you?
Yes.
And you understand the case of Kato Mano, where there are certain allegations that you did certain things incorrectly?
Yes.
And you are familiar with the case of Lieutenant General Mulli?
Yes.
Yes. And so there is nothing you would say from the terms of reference which substitute as a charge sheet is not clear to you. You're happy to proceed?
Yes.
All right. Thank you very much. Now, in your statement, we can skip paragraph 1 to paragraph 7. And then we start at paragraph 8, where you say that in relation to Kato Mano, you were not the decision maker. What are you trying to convey there?
I'm trying to convey, Chair, that the decision was made by the acting NDPP in respect of the racketeering charges.
Yes.
Advocate Chauke, try to speak louder, please. Yes, maybe you should. Is it possible for this mic to be pushed a little bit towards Advocate Chauke? I see there's virtually no space for him to put his files. You can even use the desk if you wish. You may put some of the stuff on our desk, just at the corner there, Advocate Chauke.
No, thank you, Chair.
Are you comfortable?
I'm comfortable, thanks.
Yes, thank you. Please speak loudly. Thank you.
So you say the first thing is that you the decision to authorize racketeering charges was taken by the acting National Director of Public Prosecution.
Yes, indeed.
And it's common cause that person was Advocate Jiba.
Yes.
Yes. Now, It's also common cause here that there was a range of prosecution decisions that were taken in that case, correct?
Yes.
And who took those?
Most of them, they were taken by the prosecution team, to which I would have access and have come to know about them and interface myself with them. But the ultimate decision in respect of those was taken on review. And after the review at the SCA, the matter was placed before Mr. Ngasana, who was the NDPP then, who made a similar decision, confirming the decision that I had made not to institute murder charge against General Mulli.
Yes, thank you.
Yes,
Thank you, Chair.
thank you. So we are now in the stage of Advocate Ngasana. So in relation to the decisions that you played a role in, which is the coordination over the criminal prosecution of Major General Boysen and others, and the decision-making in relation to Lieutenant General Mulli. his view was that there was no need for any disciplinary steps against you.
Indeed. In fact, he did not see any misconduct or improper conduct on my part.
Then we know that Advocate Ngasana was replaced by Advocate Sean Abrahams.
Yes.
What was his view in relation to these two decisions?
Advocate Abraham, in fact, invited me into a meeting when he had just been appointed with the prosecution team and those who were part of one way or another part of the Catomania matter, in which he acknowledged my contribution that I made there, and then he thanked me for my contribution in that case.
Yes. So, but what was his view about whether your role in the Ndluli matter or your role in the Kaitomano matter amounts to misconduct, that you should be facing a disciplinary inquiry?
No, not at all, Chair. In fact, like I indicated, in respect of the Kaitomana, he thanked me for the role that I had played in assisting that, because he was going to reconsider those that matter of Kaitomana. In respect of the Ndluli matter, it was just an information sharing, because the case had been placed on the roll, and the decision of Mr. Ngasana already was final. So he had really no issue or to consider, especially in respect of the Ndluli matter.
Yes, and then Advocate Abrahams was then replaced by Advocate Batoyi.
Yes.
Is that where things changed?
Indeed.
That's what I don't understand. I mean, 3 NDPPs have looked into this, and they have said, according to them, there's no basis for this. And then some 15 years later, someone else comes and they say, no, we should resuscitate something that happened 15 years ago. What is your comment on that?
My comment, Chair, is it appears suspicious, the motive. But as one would understand, there was this thing of the MK being captured and whatever, and I think Advocate Batoyi, I became one of those that would have to undergo a form of some discipline or a form of some inquiry, because the media narrative and what she came to say within the NPA was that there are prosecutors, one or another, who are in the NPA whose names were mentioned, the Zondo Commission, and who also were supposed to file statement as the Zondo Commission. But that, of course, did not even consider that the issues that were being raised at the Zondo were dealt with by the other NDPPs as well.
Well, you were here when I asked Advocate Batoyi whether she had any evidence of state capture implicating you, and she said she didn't.
Indeed, I'm aware of that.
Yes. Now, how many other prosecutors were placed in some sort of a disciplinary process when Advocate Batoyi came?
About 6.
Who are they?
Advocate Musing,
Yes.
Advocate Noko, Advocate Maema, Advocate Matenjwa, and Advocate Ntlagaza, and the other one who I do not even understand how is related to Katomania and all sort of things, is Advocate Mukhatla,
Yes.
who is the SCCU regional head in Pretoria.
And then
I take it in respect of the Jiba so-called prosecutions. And out of that number, I'm the last man standing.
Yes. And yourself?
Yes.
Yes. Are these black prosecutors?
All of them.
Yes. Is this an odd thing that Advocate Batoyi came and then systematically purged black prosecutors? Yeah,
of course, it's a worrying trend, and I take it that each and every NDPP will come into the office space. They will come with their own style of management or expectations or some of the background information that they will have. But unfortunately, in this instance, it looks like the real people that had a problem and shared the radar one was this so-called black prosecutors.
Yes, now...
But of course, and correct me if I'm wrong, she seemed not to have had problems with Advocate Ngcukaitobi.
Oh, indeed.
Yes.
And maybe because now we are on this point, I must take this opportunity without going ahead of you, Advocate Ngcukaitobi.
Indeed.
On the Advocate Ngcukaitobi's point. This point ties up with paragraph 8 that we have referred to about a decision. Also must be considered, I think, in relation to paragraph 13, the jurisdictional straddling point.
Yes.
And then also can be read in conjunction with paragraph 70 of Advocate Batoi's affidavit. We may not have it right in front of us, but it is the paragraph in which she was dealing with the jurisdictional straddling. When I read the statement of Advocate Ngcukaitobi, which you have annexed after AC1, that statement of Advocate Ngcukaitobi is at page 6A-6. Of your annexures.
I have it, Chair.
You have it. Yes, it appears at 6A-6 up to 7. It seems to me, on the reading of the statement, that Advocate Batoi seemed to have relied entirely on what Advocate Ngcukaitobi said or stated in this affidavit. Among others, to the effect that you led the prosecution team. And seemingly, it was on that basis that probably, correct me if I'm wrong, Advocate Batoi seemed to have believed that you made or you took prosecutorial decision. Am I correct?
Yes, I also suspected so initially, but as we'll go on, you realize that some of the opinions which were given to Advocate Batoi, those would be the ones who precipitated the sort of narration that I made a prosecutorial decision. But in respect of Advocate Ngcukaitobi was the issue of that I encroached into his jurisdiction and he was not aware of that. As I did, that's why I attached this specific annexure here. It's to demonstrate that it couldn't be correct that I encroached without his knowledge.
If you look at AC1, paragraph 1.1.
I'm there, Chair.
Yes, that's where Advocate Batoi says the decision not to prosecute in this matter, or rather it says, as you are aware, after reviewing the detailed internal report prepared by senior NPA prosecutors, I made a decision not to prosecute in this matter. Advocate Ngcukaitobi, previously employed by NPA as a Deputy Director of Public Prosecutions, has testified at the State Capture Commission and filed an affidavit. In his evidence and in his affidavit, he states that you, as the leader of the prosecution team, sorry, it was not at that annexure. It is in her affidavit to the Zondo Commission, where she suggested that you were the leader of that Katomena prosecution team, if I may put it that way. You acted as a lead prosecutor. Now, given that information, you remember that Advocate Batoi had decided not to take any step until the decision or the findings by the Zondo Commission.
Yes, I remember that.
Now, she writes to you, telling you about this statement by Advocate Mlocho. Whereafter, she then writes to the President. If it is correct, as you state in paragraph 8, that you did not make any prosecutorial decision, does the issue of a jurisdictional strangling arise? You
No.
say it doesn't at 13.
Yeah, it doesn't arise here because the decision in respect of racketeering matters can only be made by the NDPP.
I'm trying to figure it out in my mind as to how Advocate Batoi comes to this conclusion, given the provisions of Section 2.1 of POCA. What do you think might have actuated her to come to that conclusion?
Advocate Batoi was looking for something that will stick about the conduct or otherwise of Advocate Chauke. So I think in the whole scheme of many of the cases that I've dealt with in the division, this case of Katomania and the Mulli were the ones that she could have, and where she wanted to impute a particular misconduct on my part. But on the reading and even on the record, you will see it very clear that there was a prosecution team, there was a team leader, I was the coordinator in the supervisory role, and I could not have made a decision in terms of the law in any case in respect of the matters.
Now, we know, having listened to the evidence of Advocate Maema, Advocate Noku, and having read some of the statements in the record, that the role that you played was very limited. Is that of a coordinator.
Indeed.
Now, when you look at the affidavit of Advocate Batoi at paragraph 70 of her affidavit, she seems, in relation to that aspect, the decision making, she seemed to conflate different concepts. Perhaps you can read it from the transcripts because that forms part of her evidence. In the transcript, she sought to explain the following, and I'd like you to assist us in understanding these concepts that she refers to. You may not have the transcript in front of you, but I'm going to refer to the transcript of the 25th, day 4, the 25th of November, 2025, day 4, page 28 of 98. This aspect was dealt with extensively, because she seemed to make much of this jurisdictional strategy and suggested that you acted unlawfully. I'm raising this well aware of the fact that this issue does not directly arise from the terms of reference. But because it was dealt with very extensively by her, where she also referred to the provisions of the Constitution, suggesting that you acted unconstitutionally and unlawfully in the sense that you did not comply with the NPA Act, I would like you to deal with it and refer you to that part of the transcription where she said the following. She was asked these following questions. Advocate Mhlamunyane asked, yeah, maybe before you proceed, it brings us to the issue of a DPP, a Section 6 DPP of one jurisdiction exercising powers or functions in another jurisdiction. If you can explain that in full, the circumstances under which a Section 6 DPP of one jurisdiction can exercise his or functions in another jurisdiction. And Advocate Batoye answers as follows. So it is clear from the Act, the Constitution and the Act, Section 6 DPP has jurisdiction for all matters falling within his or her area of jurisdiction in which they have been appointed. In fact, the Mokoro inquiry found that there is not a circumstance that is in fact, if one looks at the Act, the Constitution, it does not permit that a Section DPP oversees prosecutors. You can underline that word, taking place in the area of jurisdiction of another. Later, when I asked her questions, Advocate Batoye then read paragraph 70 of her affidavit, which reads at page 29 of 98, we quote, the relevant part that is there is no provision in the NPA that deals with a scenario where a DPP from one jurisdiction can exercise powers in the area of another DPP. So it is not in the Act. It is not in the policy. It is not in the directives. A DPP cannot take decisions in respect of another DPP's area of jurisdiction. In other words, the DPP of one jurisdiction cannot exercise jurisdiction over prosecutions of another. It means that a DPP of one area cannot control, direct, run with, supervise, and coordinate a prosecution falling within the jurisdiction. I suppose she uses these phrases to suggest that these phrases means you were making a decision according to her evidence.
Which is unfortunate, Chair. Unfortunate in the sense that the decisions that she's making, she's referring to, are the decisions which the prosecution team would have communicated, which the ultimate decision, which the NDPP herself would make. I differ with her in terms of the interpretation of the powers of the NDPP in respect of allocation or delegation of work to a DPP of one jurisdiction or to another. That is common cause, even as I'm sitting here, to the extent that I'm on suspension, there's a DPP sitting in Johannesburg who's from the Northern Cape. Now, a blanket characterization of that a DPP from one jurisdiction cannot do work in another jurisdiction is legally flawed. Consequently, the same scenario that in the DPP KZN, I was overseeing a matter, not the division of the DPP in KZN. It was a specific matter which my understanding, and in terms of the NPA Act, Section 20 subsection 3, I think that the the NDPP has got the power to delegate responsibilities to a DPP, which is not expressly excluded in the jurisdiction. My understanding is that even then, Advocate Jiva did not delegate me to make decisions in respect of the matter that was based in KZN. And I do not know how she came to that conclusion that I made the decisions, because the record is very clear. I made no such decision.
But assuming that even the prosecution team, that is the Advocate Maema's team, were delegated to make decisions, the decision in relation to this very Katomena charges were the poker charges.
Indeed.
And correct me, in respect of which only the NDPP could exercise her powers.
Indeed, Chair.
Meaning, if I'm correct, that even the prosecution team of Mr. Maema, they could not alone, without the NDPP deciding, make any such decision insofar as the racketeering charges are concerned.
Indeed, Chair.
So if my understanding following your answers is correct, that issue of you having allegedly acted ultra-virus because you exercised powers outside your jurisdiction fall away.
Indeed. I actually, in the initial stage of the reasons that I was asked and then I was advancing, and even when I demonstrated to her to say, look, this was happening, even on her own. She took the matter of the cattle miner and she gave it to Advocate Chauke, who was the DPP in the Western Cape, for him to have a look with the other people and the like. So if on her interpretation that is not doable, she could not have done that. I'm referring to the famous Chauke report.
And you're referring to Mr. Chauke's report in which you were exculpated?
In fact, no. The panel where Chauke sat with Advocate Tenga and Advocate Mamabolo, where they made assessment according to them that there were no justification for racketeering charges. But that report, of course, as I indicated, it also did not insinuate any misconduct on the part of the prosecution team or myself.
Yes, thank you, Advocate Ngcukaitobi.
Thank you, Madam Chair. Mr. Chauke, you know, we've covered a lot of ground in this exchange with the Chair. Do you still want to talk about your CV? Or are you
I can do that.
Well, we know now. We know now who Advocate Chauke is.
All right.
You told us even earlier when we
Yes.
started.
Yes. All right. So there's the first 10 pages we can skip.
Yes.
Okay. That's fine.
Thank you.
And then on the allegations, I think we've also covered a lot of this ground before, what the allegations against you are. So those 2 pages that seek to summarize the charges, we can skip. And then the background to the inquiry, I think everyone knows the background to the inquiry. And the basis for the establishment of the inquiry. You may wish to say something about the opinions that appear from paragraph 47 just briefly.
Yeah. Thank you, Chair.
Yes.
Let me start with the one that is very significant of Advocate Chauke, which after the opinions of Advocate Nalane SC, Advocate Mayanecha, and his assessment, he made that recommendation to Advocate Batoy that there's no basis for her to recommend that there should be an inquiry into my fitness to hold office. I'm saying this because this specific memorandum was neither disclosed to me then or to the President when the application for my fitness to hold office was made. I'm saying this because Advocate Chauke, as you would have understood, he was the National Deputy Director of Public Prosecutions, who was reporting to Advocate Shamila Pato, and who was internal with experience, and who advised her that there's no basis for her to institute. But having said that, on the receipt of that, you'll see there is an opinion of prepared by Dr. David Broughton. He's a senior state advocate in her office. I think he's a legal advisor and the like, who she asked, and even the record will indicate here that he gave an opinion, and his opinion was about jurisdiction, put it that way, in the main. It did not deal with specifically in depth about the merits of the racketeering charges. And Dr. Broughton then made a recommendation that he thinks there is a case for me to answer in respect of the Boysen matter, the so-called Katomania matter. But he also recommended that there is no basis for an inquiry into my fitness to hold office in respect of the Mulli matter. But you will see that Dr. Broughton was asked to make another opinion, which was to seek to get the reasons for her to be able to be justified to make that recommendation. Now, let me get to the memorandum of prepared by Advocate Gathali SC. I'm afraid, and I'm really concerned that
just before you get there, the opinion, I'm not sure how they have arranged this for you to make it easy for you to find them. But the opinion of Dr. Broughton, the first opinion, which is dated the 23rd of February 2023.
Yes.
I do need to spend a few minutes with you on that one because it became the subject matter of a discussion between myself and Advocate Batoy.
Yes.
Now that is at LO 00149. LO1. Yes.
00149.
Yes, 00149. Yes.
I'm there, Chair.
Now, when you look at LO 00163, okay, and under the heading analysis, okay, are you there?
Yes.
And the first subheading is the withdrawal of the murder and related charges in the Mulli case.
Indeed.
Yes. What did Dr. Broughton say?
In the light of the findings in the SCA FUL decision, as referred to above, no recommendation is made herein that the section 12 subsection 6A inquiry be instituted against Advocate Chauke relating to the withdrawal decision in the Mulli case and referring the matter charge to an inquest instead.
Now, so when you read that, what does that mean?
It simply means that Dr. Bratton did not see, like Advocate Chauke, that there is no basis for an inquiry to be held against me in respect of the Mulli matter.
You see, the problem is this, the statement under oath signed by Advocate Batoyi alleges that Dr. Broughton, she says, the reason I asked Advocate Harley is because Dr. Broughton did not deal with the Mulli matter in his opinion. Is that factually correct?
It's incorrect. It's actually misleading the panel,
yes.
Because the record is there. And I remember exactly when she was testifying here, and when she was confronted about it, she couldn't explain. Yes. She sought to say, this is not a recommendation.
Yes, no, I understand it, whatever its status is, but the fact that she says, the word that she used is that Dr. Broughton did not deal. Right? We can go to this. I think they've opened now for you in the statement of Advocate Batoyi.
Yes.
Paragraph 173.
Yes, I'm there.
So if you read paragraph 173, it says, on 23 February 2023, Dr. Broughton provided me with his opinion. He concluded that I should make a recommendation to the President regarding the fitness of Advocate Chauke to hold office in respect of his involvement with and the handling of the poison matter. Now look at the following sentence there. He did not deal with the Mulli matter. Can you see that?
Yes.
Yes. Now, we've now gone through paragraph 45 of Dr. Broughton's evidence, and we've seen what it says. So it's not about what she said, or what he said. It's the fact that Advocate Batoyi, under oath, claimed that Dr. Broughton did not deal with the Mulli matter.
Which is a misrepresentation, Chair.
Yes.
Because the record indicates clearly that Dr. Broughton dealt with the Mulli matter.
Yes. Now, at paragraph 176, I think it's that same page. What does Advocate Batoyi say there?
He says his opinion was based, once again, on Advocate Chauke's handling of poison matter, aspect of it. He did not deal with the Mulli matter.
Yes. Now, what would you say about that?
It's a misrepresentation, because the record as we have it indicates the contrary.
Yes, yes. Now, we can then deal with how he dealt with it. You haven't clarified that it's actually a misrepresentation that he did not deal with it.
Yes.
Now, the way he dealt with it was that no recommendation is made.
Yes.
How did he deal with the Boyson matter?
On the paragraph 46 of his opinion to LO 00163, to which you referred to.
Yes.
There's thirdly there the Boyson Catomania case. The evidence which Advocate Mlocha gave at the State Conduct Commission has not been presented to me, and thus I'm not at this stage not able to comment thereon, unless further time is afforded to me to search for the evidence on the official State Capture Commission website, if same cannot be provided to me by the NPA. Advocate Nalan SC had regard to this evidence and the evidence presented by Advocate Mlocha at the Mkhoro inquiry, as well as the other evidence dealt with and findings made in the Mkhoro report relating to the boys and Catomania prosecution. Now, I don't know if you want me to deal with that or to go immediately to his recommendation in which he was...
No, I want you to deal with that up until paragraph 50 because...
Indeed.
there is a sleight of hand in what has happened here versus what Dr. Broughton actually recommended.
Indeed. Advocate Nalana SC submits as follows. If one reads Mlocha's affidavit to the police, together with the report of the Commission Horror Inquiry, dealing with the evidence of Jiba and Nogo, and his evidence at the Zondo Commission, it seems that Chauke's involvement in the prosecution was much deeper and more involved than simply acting as a coordinator. He went to the extent of asking Mlocha to sign the indictment. Mlocha refused to sign the indictment without the prosecution memo or report. The commission report suggests that Mlocha considered that Chauke was asking him to do unlawful acts. It is respectfully submitted that evidence presented at the Mkhoro inquiry and findings made in the Mkhoro report pertaining to Advocate Chauke's involvement with and role in the handling of the boys and Katomania case support a submission being made to the President for the institution of Section 12, subsection 6A inquiry against Advocate Chauke.
Now, if you can just stop there. You see, this is where I say there is a sleight of hand. The factual foundation for all of this that he is recommending is that you tried to force Advocate Mlocha to sign an indictment. Remember that?
Yes.
Yeah. Now, that submission was made here in this inquiry.
Yes.
And I asked the evidence leader who was cross-examining Advocate Mayema to show us where Mr. Chauke is attempting to force Mr. Mlocha to sign an indictment. You remember that?
Yes.
What did the evidence leader say?
He said, no, there's no way that it's the case, and he withdrew.
Yes, he withdrew the question.
Yes.
Now, when you look at the actual affidavit of Mr. Mlocha, which is what the chair was talking about,
yes,
at 6A/6.
Yeah.
Read everything there and read it aloud. And show me where there is a line that says, Advocate Chauke forced me to sign an indictment.
Let me read it for the record, Chair.
Yes.
I, Cyril Simpiwe Mlocha, with ID, hereby state in English that I'm currently employed by the National Prosecuting Authority as a Deputy Director of Public Prosecutions, and I'm stationed at the Office of the Director of Public Prosecutions, Pietermaritzburg, KwaZulu-Natal. On 17 May 2010 until 9 July 2012, I was acting as a Director of Public Prosecutions, KwaZulu-Natal. Between January 2012 and March 2012, while driving to Port Shepstone, I received a call from Advocate Nomgcobo Jiba, who was acting as the National Director of Public Prosecutions at the time. She informed me that there was a matter where, because of pressure, we had to enroll as a matter of urgency. I informed her that I would first read the dockets and make a decision accordingly. She stated that the matter was urgent. I responded that I did not have prosecutors to urgently look at the dockets. She informed me that because she was at the OR Tambo Airport, she was going to call me later. She did not call me later. A few days later, I received a call from Advocate Chauke informing me that he had been instructed by Advocate Jiba to send a team of prosecutors to prosecute the accused in the Katomania case. He told me that there were very sensitive security issues surrounding the matter. I told him that I was going to attend the DPP's meeting at VGM on 29 May 2012. So we were going to discuss the matter further.
So if you just stop there now, in the conversation you held with him, is there anything here where Advocate Mlocha says, in that conversation, Advocate Chauke told me to sign an indictment?
No.
All right, proceed.
On 29 May 2012, I attended the DPP's meeting at VGM. While the meeting was in progress, Advocate Chauke told me that Advocate Jiba wanted to see us urgently in her office. I went with Advocate Chauke to Jiba's office. In Advocate Jiba's office, Advocate Chauke told Advocate Jiba that he can't discuss everything relating to the matter as he had serious security concerns, and there was a possibility of investigation necessitating arrest or even advocating the office of the DPP KZN. Advocate Jiba told the two of us that she had procured a legal opinion from Advocate Gerald Nel in the legal affairs section, stating that I can sign the delegation for the prosecutors who will be prosecuting in the matter. She further told us that the indictment would, in terms of this legal opinion, be signed by me.
So now just stop there. Who is telling Advocate Mlocho who is going to sign the indictment?
It's Mlocha saying that Advocate Jiba said he is going to sign the indictment.
Yes. Is there anything that says it's Advocate Chauke who's saying that he will sign the indictment?
No, not at once.
Continue.
I told Advocate Jiba and Advocate Chauke that I was going to sign the indictment only if it was accompanied by the prosecutor's memo or report detailing evidence implicating each accused as individual and the evidence implicating the accused as a collective. This meeting ended. On 12 June 2012, Advocate Chauke's personal assistant, Ms. Mameki Suping, emailed me only the indictment without the prosecutor's memo or a report. I thereafter exchanged a number of emails with Advocate Chauke, copying in Advocate Jiba, her personal assistant and Advocate Tokoma Jokweni, requesting Advocate Chauke to give me the prosecutor's memo or report as per initial agreement. My acting appointment came to an end on 9 July 2012. I never had anything to do with the matter after the 9th of July 2012.
Yes. Now, let's go through that. So, according to this affidavit, is there anywhere where Advocate Mlocho alleges that Advocate Chauke attempted to force me to sign an indictment?
No, Chair.
Yes. Now, we go to the underlying emails that were exchanged at the time.
Yes.
So, these you will find under B2. So it's under the boys in bundle B2. Do you have those? I want to start at B579. You've got it.
It should be B3. B2, it's end. B3.
No, you are right, it's B3. Sorry. Yes, you are correct. So start at
You say
579, yes, because the emails are not sequential, they are in reverse. So it starts at the back and it goes forward.
What is the B number on that?
579.
Yes, I have it, Chair.
Thank you. So, if you remember the last paragraph from the affidavit of Advocate Mlocho said that Ms. Suping, who was your PA, sent him an indictment, but he says nothing about a message from you forcing him to sign the indictment. Remember that?
Yes.
Now, he says that was sent on the 12th of June 2012. Remember that?
Yes.
Now, we know that email at B579. It is dated 12 June 2012, 0129, from Zitmameki Suping.
Suping.
Yes. and it has no message. It is just an attachment.
Yes.
Indictment Ketomano. Is that correct?
Yes.
Now, thereafter, what we get is an email from him to you,
Yes.
from Mr. Mlotshwa to yourself,
Yes.
where he refers to a telephonic conversation.
Yes.
Now, the telephonic conversations that were held between the two of you are recorded in his own affidavit, where he says it was Advocate Jiba who says sign the, it will be signed, doesn't say sign it, says it will have to be signed by you.
Yes.
Yes. Now, he then says, kindly furnish me paragraph 2 with the prosecutor's memo or report so that I can have a wrap-around view of the matter. The report must also have the police station and case numbers so that we can open up the DPP's file. Correct?
Yes.
So far, nothing from you says sign this memorandum. sign this indictment.
Yes.
We then look at your response, which is on the 12th of June, 5:14 p.m. at page 578. Correct?
On mine is 577. On the B bundle, B3.
Your response.
It's B0057.
Yes.
577.
No,
And also us, I think if you look at the numbering council, the first email was at 00578
8. Yes.
by Mamiki Shuping to Mr. Mlotshwa, which is the first one. The second one was from Mr. Mlotshwa at the bottom of 577 to Advocate Chauke, and the third one on the same page, 00577, by Advocate Chauke to Mr. Mlotshwa.
I see. Okay, then I think the witness has the same numbering as the panel,
Yes.
and I have a different numbering. So you say it's not 578, it's 577.
Yes, 577. The previous one of Mamiki to Mlotshwa is 00578.
Okay,
Yes.
no, that's
B00578.
well, let's work on 577, because that I think is consistent with the panel.
Yes.
So that's the email from you on the same day
Yes.
with 5 paragraphs.
Yes.
Yes. Now, you can read that and tell me where you find any instruction on him by you, on Mr. Mlotshwa by yourself, to sign an indictment.
I can read the email onto the record, Chair.
Yes.
Dear Advocate Mlotshwa, who is the prosecutor that you are referring to? I have forwarded to you the indictment which has all the detailed summary by which you ought to be in a position to open your office file. I also forwarded to you details of the inquest with police case numbers, etc., to which you referred to Advocate Jokoma Joken for reasons that I do not follow and understand. The indictment with respect gives you the whole view of the matter. You are kindly and fervently requested to please discuss any issue, if any, with me. I really do not see any need for me to give you any report other than what I have forwarded to you already. Please, if I misunderstand you, make me understand. I do not want to play you or undermine your jurisdictional authority in any way whatsoever. There are serious issues of security in this matter, which, if necessary, you will be briefed about, which are not relevant to you, and I cannot expose such to you at this stage. I have also learned with utter dismay that you have now issued an instruction to the senior prosecutors that all dockets that are with us must be brought to you. What is not happening here, my brother? Please, if you have any issues again, talk to me or arrange that we see the acting NDPP urgently. Another issue of concern to me is the delay in you issuing the instruction of the reopening of the inquest, in view of the fact that you have been requested to sign the indictment, which must be preceded by your decision to reopen the inquest.
So I'll stop there. Now, what does that sentence mean? Because that's the only time there's a reference to the indictment, but what is it saying?
It's saying that we need to consider the issue of the inquest so that it should precede his signing of the indictment.
No, but what does it say about the indictment?
It says that which has been requested to sign the indictment, which must be preceded by your decision to open.
That paragraph, that passage that talks about the indictment, what does it say? It says you have been requested.
Yes.
By who?
By Jiba.
Yes.
Yes.
And then you can continue the rest of it. It's got nothing to do with you saying to him, he must sign the indictment.
Yeah. If this makes you uncomfortable, please indicate so that I may urgently take the matter up with the NDPP. I do not want to step on your toes. I was informed that you agreed and arranged with the acting NDPP for somebody from outside to do the prosecution in these matters. If you have now a change of heart, please indicate so that we may resolve it as soon as possible. Regards.
You see, this is the problem. There is no other correspondence in this case that deals with this, except what we've read so far.
Yes.
Right. Now you have a scenario in which Dr. Broughton writes in a report that you gave an instruction to Mr. Mlotshwa to sign an indictment. You also have another scenario in which there is a finding by the Mokgoro Commission that you attempted to force Mr. Mlotshwa to sign an indictment. But there is no factual foundation for any of these things anywhere.
Indeed, there is none.
Yes. And then you have the evidence leaders here just repeating the line, just repeating it without verification whatsoever. Then you have Advocate Batoi just repeating it as well without any verification whatsoever. When you go to the underlying documents, you find this is a big lie. What do you say to that?
The state capture narrative, Chair, is what is at play. People had to find a reason to try and justify that narrative that there is something untoward that this people or this person is doing, especially in respect of this Katomania matter. Yeah. That is, in essence, what it is, so that you can justify that people were acting improperly, inducing, forcing some people to do that which they are not supposed to do.
Yes.
It's a real narrative.
Yes.
And it's unfortunate that your colleagues would be found to be into that narrative as well, which I appreciate. Of course, if you don't have the time, having gone through these things, you might find yourself being misled as well.
Did the commission itself make any adverse findings against you in relation to those allegations?
Not at all, Chair. Chair will remember that the Advocate Batoi herself, she said, I'm quoting her verbatim, regrettably, the Zondo Commission did not make any findings or recommendations. I underlined that word regrettably because she was disappointed that the Commission did not make that which she expected.
Yes, thank you very much.
Yeah, I just want to ask. Thank you. Advocate Chauke, as you were leading evidence, amongst others, you stated that the opinion of Advocate Ngcukaitobi, which exonerated you, was not included in the documentation that was sent to the President. It was a recommendation that an inquiry be held against you. Is that correct?
From my recollection, that is correct, because I had it came to my knowledge. In fact, I remembered in the talks then in 2023 with Advocate Chauke saying, I can't tell you, but I've made recommendation. I don't understand what is happening. So immediately when I was asked to say now I must respond by the President, I wrote to Advocate Batoi to say, oh, no, look, this is what's happening, and now it has come to my attention that there is a Broughton there is Hali, and there is a DCOC memorandum which was not disclosed, to which I did not have sight. Please, can you favor them to me? How I got to know that is when I understood from the president, when the president was asking me to explain. So that's how I understood that this would not have been disclosed.
Now, in your view, was it proper for that opinion that was exonerating you to be not disclosed to the president and even to yourself?
It was improper, and I made that point even when I responded to the president. I indicated that it's unfortunate that this was not disclosed to the president, and neither to me.
Right. It is correct that the opinions from Advocate Hali, Advocate Nalani, and maybe Advocate Kok were sought after the full SCA judgment had been released.
Yes.
Now,
in fact, all the opinions. Yes.
And that is, maybe let's talk about the ranking of power.
Yeah.
Right? Now, as a lawyer, you get a decision which now becomes precedent. And thereafter, you go and seek opinions that, amongst others, seek to negate that very judgment of the Supreme Court of Appeal. Is that proper?
It is highly improper because you are second-guessing the court. That's what it is.
Yeah. As an officer, I'm looking at this this report of Dr. Broughton, in particular this portion that we were dealing with at LO 00163, paragraph 45 thereof. LO 00163, the one that we just had now, no?
Yes.
Now, 163, ne? It's LO1. LO1.
163. Thank you, Chair. Yes, I have it.
Are you there?
Yes.
Now, it is clear from Dr. Broughton's opinion on that page at paragraph 45 in particular,
Yes.
that his decision not to recommend that the president considered subjecting you to an inquiry was informed by the judgment of the Supreme Court of Appeal.
Yes, indeed.
As an officer of court, what is your understanding? Can you then put the Supreme Court of Appeal judgment and put it in competition with other opinions that you seek to obtain?
No, not really, Chair. And the upshot of it is Dr. Broughton understood that principle, that once the court has made a decision on the matter, that's the end of the matter. If you are unhappy one way or another, you would have to indicate so by appealing or whatever. But absent that, you have to abide by the decision of the court.
Either live with it or appeal it.
That is what it is.
Now maybe let's talk about
Sorry, Chair.
Advocate, but we thank you, because she is the person who decided to still insist on getting opinions and even seeking the President to take certain steps while aware of this judgment. Now, what do you think? Does she understand that the Supreme Court of Appeal judgment should rank as superior if we are talking about the hierarchy of powers? Or is it because of lack of understanding? And I'm saying this because you say Dr. Broughton understood. And our concern is the understanding of Advocate Batohi.
Chair, I want to believe that she understood, but she was desperate. Desperate in the sense that she needed to find a reason for me to undergo this inquiry. Because even if you remember, even when she was sitting here and then she was asked about the sanctity and the finality of the court, she agreed, but she sought to try and get a narrow decision to say before this, before that, which is irrelevant and irrational in itself. But yeah, I want to give her benefit that she understood the judgments. But from where I'm sitting is a source of desperation that she had to find something that she needed for me to undergo an inquiry.
Just to wrap it up, is it correct that the SCA judgment, the full SCA judgment, did not make a finding against your conduct in respect of the Mulli case?
Indeed, Chair. That is the finding of the Supreme Court of Appeal, that my decision in respect of the Mulli matter was rational.
Thank you.
Thank you.
Thank you, Mr. Chair. I think on this topic, Mr. Chauke, that Madam Ramachakha was dealing with you, we do need to take it to its logical end. So I don't know if you've got the terms of reference in front of you.
In fact, I have them even in the copy of my statement here. I just want to get to the actual paragraph where I summarize the terms of reference.
You've got it.
And I have the copy, Chair.
You have it.
Yeah.
Now, I want to follow up this point that Madam Ramachakha is asking just on the Mulli case. Now, the Mulli case is mentioned once in the entire terms of reference, which is 3.1.2 at page 5 of the terms of reference. Is that correct?
Yes.
Now, what Advocate Batohi wants this panel to investigate is whether you failed to continue with the charges against Lieutenant General Mulli in that for the murder of Mr. Tefo Abel Ramokhibe, in that you caused the charge of murder relating to the killing of Mr. Tefo Abel Ramokhibe and related charges to be withdrawn, notwithstanding that there was strong evidence justifying the institution of a prosecution in the matter, which decision caused a significant delay in proceeding with the charges concerned. Now, that's what the panel is meant to investigate. Now, the question as to whether there was evidence to proceed and whether your decision to withdraw the charge provisionally was fully litigated. Initially, there was a finding against you by Judge Murphy that your decision was irrational and it was set aside. Then it goes to the Supreme Court of Appeal, correct?
Yes.
This very question that is posed in the terms of reference.
Yes.
Now, the judgment of the Supreme Court of Appeal, you will find in the CL bundle, CL2. It starts at CL 00362.
I have it, Chair.
Now, you will see when you go to there is a specific heading that deals with the very question that is being debated, that we are supposed to debate in this panel. Now, it is at page CL 00369.
Yes, I'm there, Chair.
Under the heading, the decision to withdraw the murder and related charge.
Indeed.
Yes. Now, paragraph 43 says the following. This brings me to the decision by Chauke to withdraw the murder and related charge. So you just compare that with the charge against you here. It's the decision to withdraw the murder and related charges.
Yes.
Yeah. Then the SCA says it will be remembered that on Chauke's version, he withdrew the murder charge pending the outcome of the inquest that he had requested, and that he withdrew the 17 other related charges to avoid a fragmented trial. Now, your affidavit here advances the same defense that you advanced before the Supreme Court of Appeal.
Yes.
Then it continues, the contention by Fu was in essence that this decision was irrational. However, as I see it, the contention has not been substantiated in argument. On the face of it, the decision that the findings at an inquest could perhaps enable him to make a more informed view of the prospects of the state's case with regard to the murder charge was not irrational. It is true that the outcome of the inquest could have no impact on the 17 related charges. Now, in other words, those are not the murder charges.
Yes.
These are the other charges.
Indeed.
But Chauke never thought that it would. As I understand his reasoning, he always intended to reinstate at least some of the charges after the inquest, with or without the murder charge. What he tried to avoid, so he said, was a fragmentation of trials. That line of reasoning I do not find irrational either, particularly since the evidence supporting the related charges would also impact on the murder charge. It is true that he could have asked for a postponement of the 17 related charges pending the inquest, but we know that a postponement is not merely for the asking. It could be successfully opposed by Mulli, in which event the fragmentation which Chauke sought to avoid for understandable reasons may have become a reality.
Yes.
Now, it seems to me, you can tell me if I'm wrong, that the entire paragraph 3.1.2, which is, should I proceed with the murder charge whilst I've referred this to an inquest? Should I refer everything to an inquest? Is covered fully in paragraph 43.
Indeed. That's my understanding of the judgment.
Yes. Now, then it continues, paragraph 44, Fool's real argument, which found favor with the court a quo, paragraph 183. Now, you remember that Advocate Batoi read to this court, to this panel, paragraph 183 of the Judge Murphy judgment.
Yes.
Now, look at how the court deals with it. Is that Chauke's failure to proceed with the murder and related charges after the findings of the inquest became available was irrational. But that decision, or really his failure to apply his mind afresh to the matter after the conclusion of the inquest, was not the subject matter of the review application. It will be remembered that the review application started in May 2012, while the results of the inquest only became available in November of that year. Stated somewhat more concisely, I do not believe that the earlier decision to withdraw the charges, which is the impugned decision, can be set aside on the basis that a subsequent decision, taken in different circumstances, not to reinstate all or some of those charges, was not justified. To that extent, the appeal must therefore succeed. Now, who was the appellant that succeeded?
The NDPP.
Yes. Now, can you explain how you think that Advocate Batoi has invited this panel to reappraise findings of the Supreme Court of Appeal?
As I indicated before, the Advocate Batoi was desperate even in here to explain her understanding of the judgment. of the SCA, which I found to be very wanting, that she did not entirely understand the findings of the SCA. What she sought to accept was that Murphy J was correct in everything that he's doing, regardless of the fact that the Supreme Court of Appeal has overturned that finding of Murphy J. Because her idea and her narrative was being supported by the Murphy J judgment. That's why she placed more emphasis in respect of the Murphy J and forgot or else ignored the finding of the Superior Court.
Well, yes, you were asked that question by Madam Ramachakha in terms of the hierarchy of the courts.
Indeed.
It really doesn't matter what she thinks. There is a law in this country.
In fact, if you were to ask me now that you're asking me now, I think she has got no clue about understanding the judgment.
Look, I don't want us to be too personal to her.
No.
We must just criticize her decisions and not her.
You will pardon me, Chair. Unfortunately,
No, I understand.
It's me being criticized in my personal capacity now. It's very difficult.
No, it's also my job to
Yeah.
keep the proceedings civil.
Yes.
And two wrongs don't make a right.
Indeed, I apologize. I
Yes.
apologize.
Yes. Now, so once we have done an analysis of the irrationality of the NPA's decision to prosecute you on a matter that the SCA has already precluded any findings on, you look at the sequence of events. Dr. Broughton says no charge because there is a binding outcome of the SCA. You wanted to move then to the opinion of Advocate Gadhali, which you say is then sought after the opinion by Dr. Broughton. So I stopped you there, if you remember, 20
Yes.
minutes ago,
Yes.
which is at 47.5.
Yes.
What did you want to say there?
The opinion of Advocate Hali in respect of the Mulli matter talks in the main about the affidavit of the investigating officer which he made at the bail hearing. Absent of that, I need to understand and give this background, which
Yes.
I understood to be uncontested, that Advocate Hali was seized with these matters in the NPA as early as from 2020 or 2021, thereabout. Now, at the behest of how I understand it, he would have got institutional memory one or another, or would have formed a particular view about the matter, these matters, which he was dealing with them when he was at the Zondo Commission. Now, to find himself having to be asked for an opinion on the matters which he has been dealing with, I find it that very strange. My little understanding of the Red Book, when I did pupillage then, was that that would, at the very least, constitute conflict, that you assist with the matter and you are asked an opinion, and you give an opinion as if you are independent of what is being asked of you. But having said that, that opinion as well does not deal precisely with the findings of the SCA. It actually deals with the evidence of the investigating officer Rousseau's. My understanding from reading that appeal is as if what the investigating officer would have said at the bail hearing is what should be considered by the prosecutor or by me as the DPP, that one should follow that reasoning of Roelofs, which I find untenable. I say so, Chair, that if one looks at the background of this case, I should think Advocate Halu would have done himself a favor to defer to another of his colleagues to give that opinion, because he could not give opinion on things that you were dealing with in 7 years or so.
But an opinion is an opinion.
Indeed.
When an advocate opinion is sought, it does not mean that someone who's seeking that opinion cannot independently exercise his or her own discretion. In other words, you simply don't rubber stamp what you are told in the legal opinion.
Yes.
Especially when one is acting in the position similar to the one held by the former NDPP.
I accept and I understand. My
Who is also an advocate and an officer of court. So I'd like us not to be too personal in criticizing the legal opinions that were presented to the president, because the final decision to initiate or to request the initiation of this inquiry was that of the NDPP and not any one of those advocates who prepared opinions.
Indeed, I accept, Chair. I was responding to my thoughts, what do I think about them. But I accept the counsel.
Yes. Thank you, Madam Chair. Now, if you look at that opinion by Advocate Harley, now it appears in the LO4, yes. But do you have it, Mr. Chauke?
LO4.
Yes. You mean what page?
Page, yeah.
1047, 001047.
Indeed, Chair. I have it.
Yes. Now, there is just one slight correction that you must make to the evidence you gave, that he did not refer to the SCA judgment. At LO 001060, at paragraph 35, footnote 2.
Zero.
I'm sorry, it's 001060, 1060.
60. Thank you.
Paragraph 35, footnote 2. Can you see that?
Yes.
Yes. Can you see that there is, in fact, a reference to the SCA judgment in that footnote?
Yes.
But where you are correct is that the judgment is never engaged, particularly the paragraphs that make it clear that the decision to withdraw the charges pending an inquest is a rational decision.
Yeah. What I also indicate that paragraph, the footnote 2, relates to Lieutenant General Mulli in as far as the fraud and related charges were concerned, and not the matter.
Yes,
the
it's
matter
talking
charge.
about Advocate Mkhwebi.
Yes, it's that is reference to Advocate Mkhwebi.
I know, but I think it's still fair to say it does refer to the SCA judgment.
Indeed.
It's not fair to say it doesn't refer to the SCA
Indeed,
judgment.
I accept.
Now, the second point is, if you look at page 001055, paragraph 10.4. Can you see that?
I see that.
Yes.
Indeed, I accept that it makes reference to Lieutenant General Mulli and Chauke.
The SCA judgment. But
Yeah,
if you
the
look
SCA
at what it says, I mean, I think your broader point still remains if you just remove the other small jibes.
Which paragraph were you referring to?
10.4, Madam Chair.
10.4
Yes.
of the same
Of the
LO00
Yes.
1060?
Yes, it's now 1055, so it's a
1055.
few pages.
.4, you said.
Yes, 10.4.
Yes, thank you.
Yes. Now, this is another reference to the SCA judgment, but if you look at what it actually says, it says, in any event, even if after receiving the findings of the inquest magistrate, Advocate Chauke was satisfied that there was insufficient evidence against Lieutenant General Mulli, Advocate Chauke should have proceeded with the remaining charges as soon as the SCA judgment was delivered. Now, here, Advocate Hali is not talking about the murder charge, he's talking about the other charges. He says that you should have proceeded with the 17 charges immediately after the SCA judgment. And then he says it is in this regard inconceivable that he needed a further 2 months to make up his mind on whether to proceed with the murder charge, since he had the findings of the inquest magistrates as far back as November 2012. Then, to make matters worse, he did not proceed with the murder charge. Now, I'm not sure I understand what he is saying here, because it is after the SCA judgment which has found that your decision in relation to not proceeding with the murder charge is lawful.
Yes.
Do you understand?
No, I don't understand. I thought I accepted that maybe here there was a misunderstanding of the judgment or the sequence of what was happening, because after the SCA judgment said within two months the NDPP must make the decision whether or not the murder charge should be preferred against Mdule or not.
Yes, that's the point I wanted to refer you to. If you look at the order of the SCA judgment, the order is at CL 00371. CL2.
I'm there, Chair.
00371, Madam Chair. We remember that the criticism in paragraph 10.4 of the opinion by Mr. Hali is that after the delivery of the SCA judgment, you took too long to decide. And in any event, you decided not to proceed with the murder charge. Okay? Now, what did the SCA actually say should happen? Which is at paragraph 54.3 of the order in CL 00371.
The order reads as follows. It is recorded that the following undertaking has been finished on behalf of the first appellant.
And who is the first appellant?
The NDPP.
Yes. And who was the NDPP?
Then it was Mr. Ngasana.
Yes. Thank you.
A, to decide which of the criminal charges of murder and related crimes that were withdrawn on 2 February 2012 are to be reinstituted, and to make his decision known to the respondent within 2 months of this order. B, to provide reasons to the respondent within the same period as to why he decided not to reinstitute some, if any, of those charges.
Yes, now this is the point, is that so he does deal with it twice, but your point is that he deals with it in a manner that is inconsistent with the judgment of the SCA.
Indeed.
Yes, thank you. Now that would be a fair criticism, that's not personalized, is that correct?
I take your counsel, Chair. If I appeared to be personal, I still apologize if it came out that way.
Is the Judge of Appeal talking?
Yes. Now, thank you. Then there was an opinion by Ms. Moroka SC. I think we've dealt with that. And then there is the memorandum by Advocate Batoyi to the Minister of Justice and to the President.
Yes.
Is this the memorandum you said omitted the opinion of Advocate Chauke, which exonerated you?
Yes.
Yes. Now, I think we need to look at it because it is a very, very serious allegation that the piece of evidence that exonerated you from one of the Deputy National Directors of Public Prosecutions was actually withheld from the Minister and the President at a critical time when they had to make a decision about whether to convene this inquiry at all.
Indeed.
Leonard Jr. will find it now. So that is the, if you go back to the Ms. Shamila Batoyi statement at SB 10266.
Advocate Moroka's opinion not at LO 001064.
Yes, Madam Chair, yes, it might be there.
This
yes.
is the statement.
Yes. Now I'm looking at the opinion, at the letter from the minister. Sorry, from the NDPP to the minister. At reference at 47.7 of Advocate Chauke's statement.
Yes.
Now, the allegation you make here is that it omitted the opinion of Advocate Chauke, which exonerated you.
Yes.
So that's what I'm saying is a serious charge because it actually amounts to misleading when you don't give the President the right information on which he must make a decision. Now, that document is at SB 10266. Do you have it?
I'm trying to get it from the computer. I don't have it on the.
Yes, I think you had the annexures to the
Yeah.
Batoyi statement. Do you have it?
You're referring to the memorandum by the Chauke to the.
No. I'm not
The
talking
one
about
from the NDPP to the minister.
Correct.
Yes.
Yes. So that's SB 10266, correct?
Yes.
Now, it's written by Advocate Batoyi to Minister Lamula, and it's dated the 18th of August, 2023, correct?
Yes.
Yes. Now, if you turn over the page where it deals with the information that is in front of the NDPP.
Yes.
So the first one is the annexures that are there is Annexure A, which is the Chauke report, correct?
Let me get to that.
That is referenced in paragraph 2 of the statement.
Of the submission.
Yes. So if you look at paragraph 2, it has reference to Annexure A. That is the report by Advocate Rodney Chauke.
Yes.
Now, then the next document is a request by Ms. Batoyi to yourself to make representations, which is Annexure B.
Yes.
The next document, which is paragraph 4, is your response, Annexure C.
Yes.
Yes. Then the next one is
Here, and knowing the background of the matters and the like, I don't think it's a mistake that it was not sent.
Yes. And then you have a very strange reference here, because Dr. Broughton says to them, on the Mulli case, the SCA has spoken.
Yeah.
But the way they present that to the president and the minister is to say that Dr. Broughton did not have the facts on the Mulli case.
Yes.
Do you understand what that means? I mean, is this also an attempt to mislead, to misrepresent the facts? What actually is going on?
That's how I understand it, because on the Dr. Broughton's analysis and his recommendation, this fact was there.
Yes.
That there is no basis, and it does not recommend that an inquiry should be instituted in respect of the Mulli matter.
Yes. Yes. So that's what you wanted to address in relation to paragraph 47.7.
Indeed.
All right. Thank you very much. And that is what we've dealt with at 48, 49, 50, 51. Yes. Yes. In your statement at AC9, so maybe you can go there now.
You say AC9?
Yes. So it's 6A43. Remember that I was speculating about whether this was an inadvertent omission or a deliberate omission. Now, Mr. Ramukhale shows me that if you go to 6A43 and you look at the email dated the 4th of April 2025, can you see that?
I see that.
And there is a letter there's an email to yourself from Muzikaifani Madlala.
Yes.
Who is Muzikaifani Madlala?
He's the director in the NDPP's office.
He actually says, as per the NDPP's directive, please find Advocate Chauke memorandum. The NDPP considered that this was an internal memorandum from Advocate Chauke that did not take into account all the evidence in the matter.
Yes.
In hindsight, however, the NDPP thought it's only fair to make the memorandum available to you. So it seems that the decision was a deliberate decision.
Yes.
She applied her mind to it and she elected not to disclose it.
Indeed. That's how I understand it.
Yes. Then we've dealt with paragraph 51, 52, 53. It goes on to 56. Yes. We will come back to cover Mulli in full, but we are just laying the foundation now. The case of Mr. Mulli in full, laying the foundation.
Before you proceed, Counsel, I'm reminded by my sister that this is an opportune time for a comfort break. We propose to adjourn for 10 minutes. That is until Thank you. Advocate Chauke, you remain under oath.
Thank you, Chair. I confirm.
You may proceed at Peter, please.
Thank you, Madam Chair. Mr. Chauke, I think we need to just go a step back on this issue of the suppression of information by Advocate Batoi. In page 6A40, which is AC7,
AC7.
yes,
Page
6A40.
I'm there, Chair.
Yes. Now that's how this issue came about. You were responding to Advocate Batoi to
Yes.
try and understand the case against you where the president had asked you to make representations about why you should not be suspended, correct?
Yes.
Now, you then say in paragraph 2, I'm in the process of finalizing the issue of financial assistance with the state attorney to brief counsel to assist me in the matter. I'm hopeful that this issue will be resolved in a few days. In the meanwhile, I am aware that legal opinions were obtained by your office from the following counsels: Dr. Broughton, Advocate Gathali SC, and Advocate Rodney Tikok submission after having received written explanations from myself on his request. Now, this opinion of Mr. Tikok appears to have been confidential, let me put it that way. Would you agree with that?
Yeah, that's from how it came about. That's how I understood.
And
it
how-
could not
how-
be it could not be confidential as against me, and
Yes, yes.
with the nature of the proceedings as they were. To that
Yes.
extent, I don't think
Yes.
there
Well,
was.
certainly it wasn't disclosed to you
Yes.
for various reasons. But how did you know of its existence? I mean, the fact of its existence is not something that was generally known.
That tells no tale.
Okay. Dead man tell no tale. Okay.
Yeah.
That's
Advocate Cook had informed me then in 2023 when this was made to say, I made a recommendation. I don't know why she's still proceeding.
I see.
Yeah.
Now, anyway, you asked for it, and then the
But if, I beg your pardon, Counsel, if it was considered to be an internal memorandum, does that in itself suggest that it was confidential?
No, not at all.
Internal memos at the NPA, are they considered to be confidential matters even for people or advocates who are within the NPA itself?
Not at all. That's why I was qualifying it to the extent that it's confidential to the outside. But here it's a process that affects me, and this is about me. It cannot be confidential as against me.
yes.
Yes, I'd like to know if no charges were preferred against you,
Yes.
but as a DPP,
Yeah.
wouldn't you be entitled to know what was happening within the NPA as one of the senior advocates there?
Of course.
Would such an internal memo be hidden against you, or would you be deprived from knowing about such an internal memo?
No, not at all. But as I say, Chairperson, this was about the specific conduct of me. Now it will not be in a position where if there is an EXCO meeting or whatever, it could not necessarily be discussed. Information could be said. We are in the process of doing this with Advocate Chauke. We are following the processes. But it is close to say this is what Chauke is doing and all sort of things. That I don't think she will do that because within the personnel matters, the practice is that you don't discuss one's misconduct with another.
Yes, thank you.
Thank you.
Just one follow up. You have stated that Advocate Chauke told you that he's surprised that the NDPP is still pursuing the issue of inquiry, notwithstanding the fact that he has written an opinion to the contrary. Now, the fact that this was actually disclosed to you by the author of the opinion, would that remain or become a confidential opinion?
Not at all. That's why I was saying that he informed me that he made a recommendation, but he's surprised that the recommendation is still being made.
Yeah, this I just ask over and above what my sister has already dealt with, but to say even over and above, the author never saw it as a confidential document.
No.
Yes. Now, it seems that when you made the request and said, I'm aware of these documents, please give it to me. It was still not given to you if you look at AC8.
Yes.
Because AC8, which is at 6A/42, is a letter by you to the NDPP in which you say in paragraph 2, I do notice, however, that item 3.3, Advocate Rodney Chauke's submission, after having received written explanations from myself on his request, was not included.
Yes.
Was there any explanation why they did not include it in the first response?
No, there was no explanation.
And then you said, considering that my written representations to the President are due on Monday, 7 April 2025, I would appreciate it if you could assist with this request urgently. So it's only in that context that on the 4th of April 2025, which seems to have been a Friday, at 5 minutes to 11 in the evening, that the memorandum was given to you.
Yes.
Literally with 1 day left before you made representations.
Yes, I can disclose to you, Chair, that she was always under the impression that I'm not aware of the Chauke's submission.
Yes. Now, there is a further disturbing element of this, the suppression of this information. When you look at the opinion, well, not an opinion, the letter from the NDPP in the correspondence bundle C, this one, at C00024.
I'm there, Chair.
Yes. Yes. So specifically at page 00028. So this is a response to the minister who has asked two things. One, explain the delay in the institution of these proceedings. And number two, explain the existence of these various opinions. Why are you cherry-picking, taking some, and not all.
Yes.
Sorry, the president, but it's written via the minister.
Yes.
Yes. Now, if you look at C00028, Advocate Patoi's response in the third bullet point,
I'm there.
this is how she explains this. Deputy National Director of Public Prosecutions, Chauke, considered these opinions and submitted a memorandum to the NDPP, wherein he expressed his own opinion on the matter and made a recommendation.
Yes. Yes, I see
Now,
that.
when you look at this, it's the second time it seems the president is being misled about what Advocate Chauke said. Firstly, there was no disclosure at all.
Yeah.
And the secondly, when there is a request about it, the explanation that is given is that he has expressed his opinion and made a recommendation.
Yes.
But there is no disclosure of the views of Advocate Chauke.
What the recommendation is.
Yes. Now, wouldn't you agree that it seems that you have a scenario in which the decision makers are not being placed in a position to make an informed decision about your situation?
Indeed, that has always been my point, and I even raised this in my response to the president.
Yes.
Yes.
Thank you. Now, I want to then go back to your statement. We've gone through up until page 20.
Yes.
And we looked at the implications of various judgments in relation to the case against Lieutenant General Mulli. But there are also judgments in relation to the case of Keitomano.
Indeed.
Yes. And two judgments in particular. First judgment is a judgment of Govan J. And the second judgment is a judgment of Lekhodi J. It has a full bench judgment with Madam Justice Hughes. The first judgment is referred to at paragraph 57 of your affidavit.
Yes.
The second judgment referred to at paragraph 60 of your judgment.
Yes.
In your own words, can you just explain, there is a lot of misunderstanding about this case, which has been fueled by people with an interest in it. That essentially, Judge Govan exonerated the Keitomano accused and proved that there was no case for racketeering.
Which is incorrect.
Yes. Just explain
The essence of Govan's judgment was
Govan
that...
J's judgment.
Sorry. The essence of Judge Govan's judgment, as we understood it, was that there is prima facie case against the accused. However, what was presented and how it was presented to him, especially with reference to the so-called unsigned statements and information that Jiba relied on. Jiba did not adequately disclose that she relied on information, or even if it's unsigned statements with specific reference to Danikas and others. And in that instance, he said he is unable to conclude that she acted rationally when she signed the implied decisions. Nowhere in the judgment that Govan J indicated that it's actually exonerating General Boyes and other accused in respect of the charges as a whole. That was our understanding, Chair.
Yes, now, I'm going to take you to that judgment, that two critical paragraphs, 39 and 40.
Yes.
The judgment is at CL2. The first judgment by Judge Govan. Yes, Madam Ramakaka, 00352.
I'm there, Chair.
Thank you. Now, that's where the judgment starts. Now, go to paragraph 38. Which is page 00359.
I'm there, Chair.
What does it say there?
Paragraph 38. I hasten to emphasize that this outcome is based purely on the facts of the present case. It does not provide a basis for opening the floodgates to applications to review and set aside decisions to issue authorizations to prosecute under Section 2, subsection 4 of POCA. If the respondent had properly understood the principle of legality, it seems to me that their responses to demands for documents or reasons might have been different. As mentioned, there is reference to the documents in correspondence, and the NDPP states that she will not detail all the information placed before her prior to her making the first in-bank decision. Had she outlined even in basic terms what these documents and information comprised, said that she had relied on them and shown that they had included information linking Mr. Boysen to the offenses in question, this application might not have seen the light of the day.
So if you stop there, so what is the judge saying here? That, look, had you told me, so you tell me that you relied on 3 documents.
Yes.
But when I look at the docket, I find 9 as an example. But if you had told me you relied on 9 documents, then I would have found differently.
That is my understanding.
Yes. All right, carry on.
The rhyme of or reason test for rationality might have been satisfied.
Yes.
The level of disclosure of the NDPP for offenses of this nature cannot be such as to prejudice the state in its conduct of a future trial. In my view, it will therefore not require an exacting, still less an exhaustive level of disclosure. De Vries found that the consideration of a request for authorization forwarded to the NDPP under cover of a letter summarizing the form and content of the charge sheet, setting out a detailed background to the charges and summarizing the evidence was sufficient. It is certainly not necessary to disclose every detail of the state's case, strategy, or evidence where this is not subject to the criminal discovery process. In the light of the provisions of POCA, it is also not necessary to have before her sworn statements from witnesses on which the state intends to rely. I expressly refrain, however, from making a positive finding as to the level of a disclosure necessary in meeting an application such as the present one, or detail required. This can only be assessed on a case-by-case basis.
Continue, paragraph 39.
Paragraph 39, it is important to note that the above findings do not amount to a finding that Mr. Boysen is not guilty of the offenses set out in counts 1 and 2 and 8 to 12. That can only be decided by way of a criminal trial. Setting aside the authorizations and decisions to prosecute also does not mean that fresh authorizations cannot be issued or fresh decisions taken to prosecute if there is a rational basis for these decisions.
Yes. Now, I mean, these paragraphs, what do they tell you about the claim that the judgment of Governor J has put paid to this case?
No, those assertions are incorrect. They are based on a particular narrative that has been developed.
Yes, you see, because the reason why I'm asking you this is because even your colleagues, Mr. de Kock, Ms. Tenga, Ms. Riley, and Mr. Mamabolo, still understood this in their own, well, I mean, we don't know if Ms. Riley and Ms. Tenga actually participated in this because they didn't sign it. It's signed by 2 out of 4, which is itself questionable. But assuming they did, they still understood the judgment to mean that it's necessary for the statements in the docket to be signed by the potential witnesses. Even Advocate Batoy, when she testified here, still understood this judgment to say that it requires signed, sworn statements in the docket. Now, you've just read for us paragraph 38. What does it say on that point?
It says that it's not necessary for the statements to be signed or to be sworn in.
Yeah, so the statements you got specifically from Mr. Danikas,
Yes.
which was not signed,
Yeah.
signed only later in 2014.
Yes.
What is the admissibility status of that statement?
In terms of the judgment and in terms of the law, those statements are admissible for the issue or authorization of the poker racketeering certificate.
Yes, I understand. Now, then there is another judgment, which again we need to go to because it has not been referenced by the NPA, but it explains the judgment of Judge Goven, J, and which you referred to at paragraph 60 of your statement.
Yes.
Now, this is the judgment of the General Council of the Bar of South Africa versus Jiba and others, which is in the same section, but at CL 00411.
I'm there, Chair.
Now, if you, I don't know if you remember the facts around this case. What had happened is that Advocate Jiba was facing two proceedings. Proceeding number one was a fitness inquiry similar to what you are going through.
Yes.
Proceeding number two was a fit and proper inquiry brought by the GCB in the High Court.
Yes.
This judgment was in respect of the case brought by the GCB in the High Court.
In the High Court, yes.
But it was still the same facts about her affidavit that had been criticized by Judge Goven, and whether that criticism would constitute a basis to say she is not fit for office.
Indeed.
Yes. Now, the judges deal with that extensively, and I want you to go to specifically starting at paragraph 51, which you will find at CL 00421.
I'm there, Chair.
Yes. That is where the judges are explaining what her affidavit is and are trying to show that Judge Goven may have been too quick in some of his conclusions.
Yeah.
What do they say?
From paragraph 44, Chair?
No, 51.
Oh, 51.
Yes, it's CL
Yeah, no, I'm there.
0042. Okay, thank you.
Paragraph 51.
51. CL? 00421, Madam Chair.
Can I proceed, Chair?
You proceed, sir.
Having regard to what is quoted above, it does not seem the statement. Jiba says that they are all statements made under oath. Is
Just
correct.
wait. Where does that come from? That quoted part. Jiba says that they are all statements under oath.
It's a sine qua non to what is being explained above in paragraph 50.
Which comes from?
Which comes from Jiba's answering affidavit.
No. That quotation, it says it's not correct. Right?
Yeah.
Does that not come from the judgment that we looked
No,
at?
that it comes from judgment. It's an analysis in respect of the Goven J judgment.
Precisely.
Yes.
Carry on then. So in other words, it's saying the finding made in the Goven J judgment does not appear to be correct.
Yes.
Yes.
Nowhere in Jiba's answering affidavit did she make such a statement. Neither did she say any of annexures NJ2, NJ3, NJ4, and NJ5 were under oath.
Yes.
Under
Again,
oath.
to stop there again.
Yes.
Was that one of the findings in the Goven J judgment that she has said that these NJ2, NJ3, NJ4, and NJ5 are under oath?
That's what it seems to have been what Governor J would have indicated, that they needed to be under oath.
Yes, well, we can go through it, but look at paragraph 49 of the judgment you are reading now.
Yeah. Paragraph 49 reads as follows. Before dealing with information placed before JIBA for written authorization in terms of Section 2, subsection 1 of POGA, it is important to reflect whether the invitation by Boysen and the adverse remarks by Governor J were based on a correct evaluation and understanding of JIBA's answering affidavit. The challenge or invitation by Boysen to JIBA was contained in the replying affidavit, and at the risk of prolonging this judgment, I repeat the contents thereof in part. She is, that is the quotation, she is invited to explain how she could have taken into account information on oath that objectively did not exist at the time of taking the decision. The invitation was made after having made allegations of mendacity in the same paragraph with reference to paragraph 21 of JIBA's answering affidavit in the Boysen matter. And because of the relevance thereto, paragraph 16.6, 16.7, and 17 of JIBA's answering affidavit in that case are repeated hereunder.
Yes.
16.1, quote.
16.6.
16.6, quote. The information under oath which was placed before me also indicated that the applicant knew or ought to have known that his subordinates were killing suspects as aforesaid instead of arresting them. 16.7. The information further revealed that unlawful activities of killing the suspects and or civilians were, in certain instances, motivated by the applicants and members of the unit's desires to enrich themselves by means of state monetary awards and or certificates for excellent performance. In this regard, I annexed a copy of an example of such a monetary award claim document as NJ1, in which, inter alia, the appellant is recommended for such an award resulting from the death of suspects. Paragraph 17. Particular reference is made in this request in regard to the statement made by Colonel Rajendra Sarjes, Mr. Aris Danikas, and Mr. Ndlondo, from which it is apparent that the applicant is well aware of the information that the respondents have in their possession relating to the murder of at least 28 people and the monetary and non-monetary awards claimed by him, the applicant, for the instrumental part that he played in these crimes. Additionally, Mr. Danikas has revealed some of the information that he has provided to the respondents and to the press, and even posted video footage thereof on YouTube. I annex copies of this statement as NJ12, NJ13, NJ13, and NJ15 respectively.
Yes. Now, if you just stop there, I mean, you've seen here the judges go back to the underlying pleadings in the case that was before Governor J.
Governor J, yes.
And they say, look, our job is to evaluate whether the allegations of mendacity that were made in that judgment are supported by the underlying evidence.
Yes.
And then they quote the underlying evidence in extenso.
Indeed.
Then they analyze it from paragraph 51.
Yes.
First thing they say that JIBA never said that all of the statements she relied on were under oath.
Indeed.
And you've seen paragraph 16.6, 16.7, and paragraph 17. Is that consistent with paragraph 51?
No. In fact, it's to the extent that it's explaining JIBA's assertion. It's what the full court is saying is JIBA is consistent in respect of what is being alleged.
Yes. But also specifically, she has never, you remember the criticism in the judgment of Governor J?
Yes.
Is that you have said that you have relied on information under oath.
Yes.
When in fact you have statements that are unsigned.
Yes.
And the judges here are saying she never said she relied on information under oath.
Indeed.
She said she relied on information.
Information.
Yes.
Yes.
Now, I know this is not a case against Advocate JIBA, but she was condemned wrongfully and ultimately lost a job in the NPA.
That was my view then, and it's still my view now.
Yes. Then it continues there that it says, under oath statements or information was made only in paras 16 and 16.6 of the answering affidavit,
Yes.
without suggesting that all of the annexures referred to in paragraph 17 of the answering affidavit in the poison matter were made under oath. Now, that's where the judges are explaining
Yes.
that there is a difference between where she says, I've relied on statements under oath, and where she says, I've relied on information.
Yes.
And then it continues the final sentence there. Therefore, the statement, the document referred to as a statement by Master Danikas, Annexure NJ3, is not a sworn statement. As stated in paragraph 31 of Gov. Nj's judgment, has to be seen in context insofar as it was understood that Jiba averred that NJ3 was a sworn statement.
Yes.
The truth is, she never said NJ3 was a sworn statement, and it could not reasonably have been so inferred, particularly reading in context paragraph 16.7 of her answering affidavit in the poison case quoted in paragraph 50 above. You see that?
Yes.
Yes. Now, you see, if you remember, when we were in this case, Advocate Patoi repeatedly said Mr. Chauke is complicit in the falsehoods that were told by
Advocate Jiba.
Advocate Jiba.
Yes.
Now, yes, thank you. My junior has pointed this out. In the Advocate Patoi's statement, if you have it in front of you,
Yes.
paragraph 180.8.
Paragraph 18.
180.8, Madam Chair.
180.8.
Yes. Do you have that?
I have that. It's on page 76 of the statement.
Yes. It says there is prima facie evidence that Advocate Chauke was complicit in the fraud and perjury charges leveled against Jiba. You see that?
I see that.
Yes. Now, because you signed a confirmatory affidavit to this affidavit.
Yes.
Yes. And that you provide. So, if you go to 377 of your statement,
I'm there, Chair.
yes, what do you say there?
The difficulty with Advocate Pato's allegations compounded by a further material fact which her affidavit does not disclose. The allegations of fraud and perjury against Jiba were in fact referred for prosecutorial consideration. The matter was considered by Advocate Ivy Tenga, the Director of Public Prosecutions for Limpopo, who declined to prosecute.
And it's here, the actual decision is referenced at B02199. So go to B02199.
B02.
02199, which is
B.
sorry, I'm also trying to work that out. It's B9.
You said B00?
219.
219.
199.
2199.
Yes.
I'm there, Chair.
Yes, I just need to find it as well. So if you are at B02199,
I'm
Is
there,
it-
Chair.
decision by Advocate Tenga to Advocate Abrahams, dated the 13th of August 2015, S versus Nomgcobo Jiba, Silverton case 622/10/2014. The case has to be dealt with in terms of Part A, prosecution of certain categories of persons, NPA Policy Directives, Paragraph 6C. I decline to prosecute Advocate Nomgcobo Jiba in all the charges preferred against him. Reasons for my decision are fully contained in my opinion. Now, the reason I ask you this is because you are now accused in paragraph 180.8 by Advocate Batoi of complicity in an offense that she knows was not prosecuted by Advocate Tenga.
Yes.
How do you explain that?
The desperation with the narrative that should find favor in respect of that I'm guilty of some conduct or that's what is at play, Chair.
And she does so in circumstances where she does not take the panel into confidence and explain that I actually know that in 2015 this was not prosecuted.
Indeed.
Now, we then go back to the underlying analysis by the judgment of Judge Lekhodi. So we've dealt with paragraph 50, 51. Then in 52, he deals specifically with the claim of mendacity.
Yeah, I'm there, Chair. 52 says the fact
yes.
that
Yes, carry on.
52 says the fact that Jiba did not avail herself of this the invitation to deal with the allegation of being mendacious, meaning not telling the truth, should also be seen in context. The allegations was made in the replying affidavit. This too, Governor J was mindful of. For the purpose of these proceedings, the criticism by Governor J should be seen in the context of what Jiba now has to say in these proceedings. Paragraph 53. When it was discovered that Boysen had raised certain issues in his replying affidavit, the prosecution team felt that it needed to respond thereto. On 14 August 2013, a meeting of the prosecution team was held. Subsequent to the meeting, a memorandum was prepared and forwarded to the defense team led by Hodes SC, in terms of which it was expected that a supplementary affidavit will be filed to explain the criticism against Jiba with regard to the annexures. On August 19, 2013, an email by Advocate Musing of the NPA was sent to Advocate Chauke.
19 August.
Sorry. In 19 August 2013,
Yes.
an email by Advocate Musing of the NPA was sent to Advocate Chauke, Director of Public Prosecutions, Johannesburg, inquiring what progress had been made with regard to the filing of a further affidavit to deal with Boysen's allegations. Subsequently, Jiba was advised by Advocate Musing that counsel had indicated that no further actions were necessary. Paragraph 54.
Yes.
Based on the explanation above, it is clear that Jiba did not ignore the serious allegations of mendaciousness made by Boysen. By seeking to file a further affidavit to explain the annexures after the replying affidavit was filed is a clear indication that she was mindful of the need to explain and correct any inaccuracies created by Boysen in his replying affidavit. Therefore, the statement, quote, despite this, the invitation by Boysen was not taken up by the NDPP by way of a request or application to deliver a further affidavit. In response to Boysen's assertion of mendacity on a part, there is a defending silence made by Governor J in paragraph 34 of this chapter ought to be seen in the context of what is explained in paragraph 53 above. Paragraph 55, similarly, the statement that, quote, regards the inaccuracies The NDPP, referring to Jiba, is after all an officer of the court. She must be taken to know how important it is to ensure that a affidavit is entirely accurate. Should be seen in the context of what is stated in paragraph 53, but even most importantly, in the context of her explanation now offered in the present proceedings.
Yes, now thank you. Now, that deals fully with the claims of mendacity, which you are now associated with it.
Indeed.
Directly by Advocate Patoi.
Indeed.
When she does not disclose to the panel that these findings by the full bench.
Indeed.
Now, then finally, the full bench deals with the question of the case that was presented. You remember that that issue was left open by Judge Govan, who said, I don't want to get into it, whether there's a good case or not.
Indeed.
The NPA must decide.
Yes.
And if it wishes to reissue, it can reissue.
Yes.
But on the same facts, another group of judges came to a somewhat different conclusion, which is set out now at paragraph 57.
Yes.
Carry on there, what does it say?
Paragraph 57.
Yes.
At the time Jiba deposed to the answering affidavit in Boysen's matter, the facts and the evidence against Boysen had been presented to her on many occasions, and she was acquainted with the case against Boysen. In her affidavit during proceedings before Govan J, she referred to Annexure NJ5 being the statement of Mr. Ndlondo, and Annexure NJ6 being the statement of Boysen. These annexures apparently did not form part of the papers before Govan J, and Jiba was not aware why that was not done. I revert to the essence of Annexures NJ5 and NJ6 later when dealing with whether Jiba had information implicating Boysen when she issued the authorization on 17 August 2012. NJ3 was the statement of Ari Danikas, which was obtained round about 18 April 2012 by General Mabula, who led the Hawks investigation team against Boysen. The drafted statement of Danikas was handed over to the prosecution team during June 2012 and formed part of the information she considered in authorizing the prosecution of Boysen. Danikas was a police reservist in the Durban Organized Crime Unit in Katomane and was at that time in Greece. He had security concerns and was unwilling to come on his own to South Africa. On or about 11 July 2012, Advocate Maema asked General Mabula to leave the statement unsigned so that the information processes outlined in the mutual legal assistance legislation, that is Section 2 and 3 of the International Cooperation in Criminal Matters Act 75 of 1996, be followed to formalize the statement. Although the witness was willing to have it signed at the South African embassy, the prosecution was confident that the statement would ultimately be signed through the process outlined as contemplated in Act 75 of 1996, but it formed the basis of the briefings to be considered by her in issuing the authorization. However, the process of signing the statement could not be finalized since the incumbent, Mr. Nkabinde, at the time of deposing to the answering affidavit in the present proceedings, had instructed to halt the process. Paragraph 58. Whilst the statement in question did not relate to the specific incident covered in the indictment, it was, however, intended to corroborate the evidence in possession of the prosecution team that Boysen was involved in the various activities giving rise to the charges against him, of similar fact evidence, which is admissible in racketeering prosecutions. Paragraph 59. An explanation.
You can skip that. I need you to go to paragraph 62.
Paragraph 62. As far as the allegation of lack of information implicating Boysen is concerned, an understanding of the applicable legal framework that was placed before JIBA and the core function of the prosecuting authority is necessary The court may hear evidence, including evidence with regard to hearsay, similar facts, or previous convictions related to offences contemplated in sections 2 of subsection 2 of section 2 of the NPA Act, notwithstanding that such evidence might otherwise be inadmissible, provided that such evidence would not render a trial unfair. This should be seen in the context of the preamble under POCA, which inter alia reads.
You don't need to read that, it's common ground.
Okay.
Paragraph 63.
Paragraph 63. In my view, the provisions of section 2(1)(e) and F referred to in paragraph 44 of this judgment are meant for the criminalization of such activities. The point I am making is this: courts, for the purposes of an exercise of its discretion in terms of section 2, subsection 2, referred to in paragraph 62 of this judgment, may rely on hearsay evidence and information and or documentation collected by the police and presented to it by the prosecution. If that is so, and courts are entitled to have regard to hearsay during trial, so too should the National Director of Public Prosecution, Jiba and Boysen's case, be entitled to rely on hearsay and similar fact evidence for the purpose of authorization as contemplated in subsection 4 of section 2 of POCA. Otherwise, pervasive presence of criminal gangs will continue to rule with impunity and fear in many of our communities, and resultantly pose harm to the well-being of many communities. Paragraph 64. As I said, one needs to be careful not to be understood as upsetting Gov and J's judgment for having reviewed Jiba's decision to prosecute Boysen. That is not an issue before this court. The issue, however, is whether in granting authorization in terms of section 2 subsection 4, Jiba was malafide or had ulterior motive, in which event the requirements of fit and proper person to remain on the role of advocates becomes relevant.
Okay, you can skip those until start at paragraph 66 again.
The essence of the information before Jiba can be summed up as follows. In addition to what's stated in paragraph 56 to 57 and 60 of this judgment, Boysen was the head of the Katomania organized crime unit in South African Police Services. Members of the police in this unit and under his command had allegedly committed crimes of a serious nature, including murders against suspects who were sometimes framed in the commission of offenses. Boysen knew, approved, and ought to have known of the commission of these offenses. As a reward for the members' unlawful activities.
If you just stop there for a moment, you know, this paragraph 66 is a critical summary.
Yes.
It says this is the information that was before Advocate Jiba, in other words, before the NDPP and the prosecutors.
Indeed.
Just repeat what it says about Boysen. It says Boysen what?
Let me just start here. Boysen was the head of the Katomania organized crime unit in the South African Police Services. Members of the police in his unit and under his command had allegedly committed crimes of a serious nature, including murders against suspects who were sometimes framed in the commission of offenses. Boysen knew, approved, and ought to have known of the commission of these offenses. As a reward for members' unlawful activities, Boysen motivated for an incentive of 10,000 for each of the 26 members of the Katomania crime unit, including Boysen himself. Boysen was also commended for outstanding services rendered in that he was part of a team who, through their commitment and dedication, arrested several crime and dangerous suspects for the murder of a police officer.
Now, you just stop there. You see, this is the full bench has already made a finding.
Yes.
That the information that you had in front of you
Yes.
showed that Boysen knew, approved, or ought to have known about the commission of the offenses.
Indeed.
That there were a number of offenses committed by this unit when Boysen was at the head. Mr. Boysen was at the head of it.
Indeed.
It couldn't be clearer. Now, you have a scenario here that Advocate Batoy is now asking this panel to reappraise whether there was information or not, because the charge is no evidence.
Indeed.
This is the second time where they are asking the panel to overturn a court.
Indeed.
Can you explain how we found ourselves in this situation? There's a rule of law in this country. The courts are supreme.
The state kept a narrative, Chair.
Okay, so you can't explain it.
That has been being sung, and the NDPP herself was here singing state capture until you had to ask whether Chauke is involved in the state capture, and said, no, there's no evidence to that effect.
Yes. Now, this is how they then concluded in paragraph 67, that given the information we've summarized was in front of you, that shows all of these elements.
Yes.
Somebody is a leader, people are committing crimes, he's motivating for them to be paid, he himself knows or ought to have known about the commission of these offenses. It says, given all of that, we cannot find that your decision is based on an ulterior motive. Now we have you also being charged of the same thing, that you've prosecuted someone without evidence. But a judge has spoken on this.
Indeed.
Yes. Now, we've covered then in your statement.
Proceed to I think you're going for the next topic. No?
Yes, I am.
Okay, thank you. Advocate Chauke, can you just maybe enlighten us about the question of whether you'll remember, in fact, let me rephrase. There's a time when evidence was laid, especially about the judgment of Nkabinde, that in his judgment he had indicated that there are concessions that Advocate Hodes had made.
Yes.
And outside court, this became a dispute because he said there are no concessions that had been made, and the court erred by alleging that he had made concessions. The question I'd like to ask you is whether these corrections that were made by the full bench, do they in some way or the other also touch on the concessions that were, according to the judge, made by Advocate Hodes?
Not in a specific way, Chair, but at the time, and that is the Advocate Lawrence Hodes SC felt very strongly about that, and even when he made an advice that this judgment should be appealed, because he felt strongly that he did not make any such concession.
Yeah, I understand. That's why I said there was a dispute. I understand that he said there were no concessions that he made. Yeah. And I also understand that there was initially a desire to appeal the case, yeah, but then ultimately a decision was there. But it's not necessary because Judge Govan had not closed the door to the NPA pursuing the matter. So all I just wanted to know is whether, not necessarily the entire corrections that were made, but whether there are elements in the corrections that were made that also have some relation to the concessions.
Indeed, if one reads the passages that I've just read to you, which indicated about whether there was evidence or not, whether there was evidence of racketeering, that because the concession, as it was said then, was said that Hodes SC considered that there was no specific evidence to relate to racketeering.
Thank you.
Thank you, Madam. In fact, Mr. Chauke, I think let's actually answer the question directly. The alleged concession was that there was no evidence from the statements implicating Mr. Boysen.
Yes.
That was the alleged concession.
Yes.
Now, when you understand the concession in those terms, we can go back, because the whole thing is dealt with fully in the statement by Advocate Sean Abrahams.
Yes.
I think it's in bundle 3 of the cross-examination bundle.
Yes.
Now, if you accept that the concession is there is no evidence from the sworn statements, from the statements rather, implicating Major General Boise.
Yes.
Now, the corrections that were made by the full bench, do they address that or not?
They do.
Yes. Now, yes, so we've now covered right up to page 22, so that's been four pages. Then you have a constitutional and legal framework that goes on for 3 pages. And then we don't have to go there. You've already started to deal with your role as the Director of Public Prosecutions.
Yes.
And you addressed the question that the chair had asked, that this was a poker prosecution,
Yes.
which falls under the purview of the national head of the prosecution service. So
Yes.
we can skip that. Then we deal from page 28 with the Cato Minor and the Boysen prosecution. Yes, I mean, maybe you can just, because we've had so much about this, but just summarize your involvement, how you got involved, etc.
Before he does that, Counsel, going back to the critical paragraph 66 of the full court, we know that Advocate Batoi did not read the dockets. She said so. Had she read at least the paragraph 66 and other paragraphs that are critical in this judgment, would she have come to the same conclusions to refer the matter to the President?
Objectively, I would say no. But what I know now is she was hell-bent to make the recommendation anyway.
But not only that, had she read the affidavit of Advocate Jiba, who was seized with the powers to authorize the racketeering, she could only do that on the basis of the information in the indictments, in the dockets.
Indeed, not even only Advocate Jiba, even Advocate Sean Abrahams.
Had she read those affidavits, which were part of the court papers, wouldn't she have thought otherwise?
Objectively, one would have
I
thought...
know it's unfair to ask you this question.
No, I understand, Chair. Objectively, one would have expected to have reconsidered the position. But remember, as I say, the narrative was out there that this is what is this was a state capture and all sort of things like that. So my understanding that she was looking for every reason to be able to fit into the narrative.
Yes. I suppose, Mr. Chauke, the question really is, an NDPP acting reasonably, if they had read this, would they have proceeded? I know there's a lot of subjective views about this.
Yeah, that's why I'm saying, Chair, that objectively, one would have expected her to have reconsidered in a position, to have reconsidered the position that she had taken. Yes.
Thank you.
Yes, thank you.
Thank you, Chair.
Yes, so I was saying that when we start at page 28 rather, take into account that for 3 months we've had a lot of evidence about Cato Man. But what we just need is a narrower issue about your own personal involvement. So you can just take us through that.
As I indicated, in my coordination role, obviously when the...
No, I think what I need is for you to say, look, in 2012, I was phoned by Advocate Jiba. He said there's a big case, please get involved, etc.
Yeah. On the 8th of March 2012, Advocate Jiba called me to say, look, there is a situation, we've got a situation where there is a case in KZN where The suspects are the members of the South African Police Services who have worked closely with the suspects and the prosecutors. And then there is a request that prosecutors from outside the province should be deployed to look into these matters. Can you please arrange to get me prosecutors from your office who will be deployed to KZN to look into these cases with the members of the DPCI and the IPAD. I accepted the request and indicated to her that I will do so. And then there was a request that the following day, I think the 9th, that I should put together those prosecution team to meet with her in her office for the briefing. And indeed, the following day, on the 9th of March 2012, as appears from my statement, where I had identified Advocate Raymond Matenjwa, who was a deputy in my office, and Advocate Jabulan Mlochwa, who was a senior state advocate, and Advocate Ntagaza, who was also a senior state advocate in my office. We proceeded to the meeting with Advocate Jiba, where we met with even police, I think Mabula and others. Then there was a discussion. Then Advocate Jiba then indicated that the leader of this prosecution team will be Advocate Mayema, but he has got some commitment. He will join later later after finalizing the issues with his DPP, J.J. Smith.
So that's dealt with at paragraphs 108, 109, and 110 of your statement. Yeah. Page 631.
Yeah, and then in the same breath, she remarked that the prosecution team is too male-dominated. Yeah. We should be in a position to get female advocates there, and that's what.
Who had put this prosecution team together? Yourself?
Yes.
Is that why it was male-dominated?
Probably. In hindsight, I thought traveling to KZN and they say is dangerous and what have you. I didn't want to expose females.
I'm sure you didn't. Yeah. All right, carry on.
So that's when I also nominated Advocate Pumeza Fuchan and Advocate Patience Muleko to form part of the prosecution team. And then the prosecution team now...
So just before you go there, because I want you to explain to the panel what was explained to be your role, because we know the role of Advocate Mayema. Why? Because it was set out in a memorandum. You are there, you are to prosecute, you're going to defend any reviews, you're going to institute any appeals, you're going to defend any appeals, because the terms of reference are there. But you are not part of the prosecution team. Yeah. You are coming in to play a coordinating role. Yeah. And you know the evidence leaders, they repeatedly say there's a section in the Act that talks about coordination and it gives that role to the DPP of the province. Now, here you are doing this job on behalf of the NDPP.
Yes.
Carry on. Just as explain that discussion, how it happened.
So the discussion was that once I was told and I accepted that they said the DPP in KZN and the prosecutors they are working close relationship and that's how they accepted. Then she indicated that my role will be doing the coordinating role and support to the prosecution team in terms of logistics and everything associated with their activities of prosecutions and now that to me included the supervisory of them their activities, which excluded that I cannot make decisions whether or not to prosecute in respect of these cases because they fall under the jurisdiction of the DPP in KZN, and she was not going to issue me with that delegation because it was not necessary. The prosecution team is the one that is going to handle that, but there is a suspicion that probably this being POGA, the decision that is going to ultimately be made, it will be made by her anyway.
Yes.
So I understood that.
Well, I understand the issue of POGA. I suppose at the time there are two considerations. One, there is POGA, which is exclusively national, but there are also all of these other subsidiary offences, which are provincial.
Yeah, that the prosecution team, especially under the leadership of Mayema, will make decisions whether or not to prosecute those cases in KZN. I understood and I was conscious about that. I should not find myself being make decisions which, if they are reviewed and the like, I might not, they'll be sustainable because I did not have been given that specific delegation. Like in most cases, that once a case has to be divided by the DPP is being sent, and then the specific request from the NDPP to say, here is the target from another division. You are hereby appointed to decide it. That did not happen.
Yes. So to try and explain this role that you are playing, which is coordinating advisory, were you doing this on behalf of Advocate Jiba?
Indeed.
Because the other option could have been for Advocate Jiba to do it herself.
Of course, or to get any other DPP and the like. And if the DPP Mlosha was comfortable that these things of close working relationship with the Katomania team was something that was comfortable, could do that. That's my understanding. Will be it would have been not necessary for me to be roped in to coordinate the activities of the team.
Yes, but I mean, on the assumption of what I've put to you, that she has the option of doing it herself
Yes.
or asking someone else, because
Yes.
This is exclusive jurisdiction.
Yes.
I mean, what would be the impact of that on the office of the NDPP?
Well, at the NDPP, there's no way that she will be in a position to coordinate things in Durban without her having to go to Durban and attend meetings, some of the briefings and all sort of things. And like, and given the nature of the office that you're running the whole of South Africa, you're not only running a specific division, it is untenable. It will not be possible.
The office would just grind to a halt.
Of course.
Now, earlier you said this is actually not unique.
Yeah.
Even Advocate Batoyi,
Yeah.
when she had to deal with this case, she asked someone from a DPP from Western
Cape and a DPP from Limpopo.
Yes, who said, look, help me with finding out whether to continue this case or withdraw it.
Yeah.
Yes. Now, is there a reason why, and I know it's unfair to ask you because, you know, it's unclear to me what they say you should have done.
I should have refused.
Yes.
That's my understanding is that.
Council has not finished asking the question.
Sorry, Chair.
Yes, because if you look at the I think it's the opinion by Advocate Harley, who says the fact that you've been asked by the NDPP does not exonerate you of your own responsibility and analysis of the law in order to know the scope of your powers.
Indeed.
That's what I need you to respond to. So I'm thankful to the chair for having assisted me to get my question out.
As I say, Chair, my understanding of the NPA Act and the powers of the NDPP, I've got a different understanding from what the opinions and Advocate Batoyi was saying, that it's not incumbent that the NDPP cannot delegate another DPP to do work of a case from another division. I beg to differ, but that probably I should, because I'm a witness, I should leave to the evidence leaders and yourself to.
No, I think the question I'm asking you is this. Bearing in mind that you are dealing with a crime that is within the exclusive preserve of the NDPP.
Yes.
And the NDPP comes to you and they says, Mr. Chauke, I need you to go and coordinate this on my behalf in KZN. I just don't have the time for it.
Yes.
And you must come and report to me on a regular basis what's going on.
Yes.
Yes. Now, is the expectation of you that you should read the Act and say, I'm sorry, Madam NDPP, this is outside of your powers? I suppose that would be a fair expectation.
That's how I understood it. That is seemed to be what was being expected of me to have done.
Yes.
Yes.
But that's the point I'm asking, is that what would be the outcome of that exercise on these facts? You would still come to the conclusion that it was lawful.
Yes.
Yes. Thank you. Now, you've addressed here... yes.
Advocate Chauke, I'm actually really trying to understand this issue. Yeah, the NDPP's exclusive powers, especially in relation to the racketeering issuance of the certificates and institution of the action. Now, there may be other cases where such applies. We say the issue of issuance of the certificate of institution of the action in respect of transgressions of these laws lies with the NDPP. What I'll request you to assist us with is, ordinarily, what is the norm? If the matters, the crime is committed in a particular jurisdiction, and the matters are to be tried even in that jurisdiction, when the NDPP seeks for or identifies the DPP that should deal with that matter, is the NDPP entitled to choose from any of the DPPs, or is the NDPP entitled to appoint the Director of Public Prosecutions of a particular or the affected area?
My understanding is that the DPP of the particular area should take responsibility for those matters.
Right, thank you. And that would also include even motivations for application for the certificates of racketeering.
Yes.
Now, let's talk about this case in particular. We understand the record says you were acting as the coordinator. You were playing that role of the coordinator. And maybe the relevant period is the period where it was Advocate Mlochwa who was the acting then. And then it's Advocate Noku, who was acting at some point and then became the permanent appointee for the position. In her evidence, Advocate Noku says that in or around August 2012, yes, you called her, inviting her to accompany you to the Judge President of KwaZulu-Natal to go and make certain arrangements regarding the bail application. You remember that?
Yes.
Yes. Now, what caught my attention is that she says you invited her to accompany you. And yeah, well, you did then go to the Judge President to see him and make arrangements, but then the Judge President then said he could only attend to the matter, even if it's not exactly that, upon receipt of a letter written on the letterhead of the KwaZulu-Natal Director of Public Prosecutions. Do you know as to why it is that the Judge President made that request?
My understanding is that the authority to indict and appear in the High Court in KZN rests with the DPP of KZN. Now, what had happened is I had to brief Advocate Nogo because she just came in. And then the following day, that's when we had to meet with the Judge President. So I had to brief her to say this is what's happening, so that she's on the loop, and then me going with her to the Judge President.
Now, you'll remember that during questioning of Advocate Noku, I think it was by Advocate Mutsenoso, but during the questioning, amongst others, she was asked a question as to whether does she see making arrangements with the Judge President, especially with regard to the bail application, whether Advocate Noku would see that as an exercise of prosecutorial powers or anything else. And she said making that arrangement constitutes, according to her, of course, constitute exercise of prosecutorial powers. And it was left at that. Now you are now here as a witness, and I think it will assist for you to clarify that issue as to whether you agree with Advocate Noku's understanding or you have a different understanding, and if you do, what is your understanding with regards to just exercising that power or undertaking that duty to make arrangements with the Judge President. Thank you.
My understanding is that that prosecutorial power is not a decision-making power. It's an arrangement for the matter to say is going to be enrolled, and that like it's not a decision whether to prosecute or not. That's how I understand it.
Okay, yeah. So what you are saying, because I've got to understand you, is that, well, it is a prosecutorial power, but it's not a decision-making power.
Yes.
Right, thank you. Another thing that I'd like to ask is about, I'm looking at the time lapse, ne? That Advocate Noku was appointed in or around the 14th of July 2012 to act to succeed Advocate Mulli. Yeah, okay, on the 9th. The record says the 12th. Thank you for the correction. On the 9th. And in her evidence, when she testified, she also said that after or around the time when the meeting was arranged, yeah, that is when she became aware of the Katomena matters, and that there were about 23 dockets involved therein. I think that can be found in paragraphs 39 to 40 of her evidence. We'll check that. But do you remember that as you were sitting?
I remember my recollection is that I had to brief her before we met with the Judge President, and that's where she would have got all the background about the cases and what the case is all about.
Well, I think I'll take you, maybe, well, I don't have time to the statement. It doesn't suggest that, but nevertheless, what it suggests is that there was a communication that you did correspondingly and possibly even telephonically to say you'll be coming for that. And she should accompany you there to make arrangements. And then she goes on to say, it is at this time that it came to my attention that the Katomena cases, there were about 23 Katomena cases and so forth. Now, the question that I want to ask is, when a person is to take over from another acting prosecutor, in this case, when she takes over from Advocate Molocha, what is the expectation and what is the practice in the national prosecutions environment? Is there supposed to be a handing over, or a person just, this one that is the end of the term and the other one comes in and starts struggling finding his or her way, or what is the position?
There is a handing over, Chair, and my understanding on record is that Advocate Mlocha did a handing over in respect of this specific matter to briefing Advocate Noko.
And do you know as to whether the post the arrangement with the judge president, as to whether there was then constant communication with Advocate Noko about these matters of the Katomena, because the KZN were involved in the Katomena cases only?
From how I understand it, the prosecution team led by Maema will be from time to time, if they were to go to KZN, then they will communicate with her. That's how I understood.
So at the time when you were then told by Attorney Ngasana that you should no longer work on the Katomena cases, Advocate Noko will then continue with the job. At the time, was it or was it not necessary for you to do the handing over, or had it already been done?
No, the handing over between me and Noko happened as at when the coordination to say I should stop coordinating, because Noko was not necessarily long. She was new in the division, so the predicament that Advocate Mlocha had about the working close relationship with the Katomania people, Noko did not have that same thing. So on the basis of that, we spoke, and then from there, she would communicate with the Advocate Maema, the team leader.
Okay, thank you.
Yeah.
Thank you.
Thank you.
Thank you, Madam. So where we were, we've dealt with 108, 109, 110, 111. I just wanted to ask you, you are now the supervisor and the coordinator of the prosecution team, and there is a legal issue that the evidence leaders wish to raise. I'm sure they'll raise it with you extensively. You can discuss it with them. But factually, when the prosecution team would meet, would you attend? What would happen? Or you'd attend some meetings and not all?
I will attend some meetings, and some meetings I will not attend between them and the prosecution, especially the meetings which were intended to brief the NDPP. I would always be in attendance in those meetings.
Yes, so it's per invitation, or when you've got something to communicate?
When I've got something to communicate, remember they will say, this is where we are, and the NDPP need to be kept in the loop, because this is a high-profile matter. She needs to, once she's being asked by the authorities, she should be in a position to explain progress, say this is what is happening with this matter.
Yes. All right, thank you. And then if you turn over the page, there are further meetings that you attend. 3 May 2012, 17 May 2012, 22 May 2012, 24 May 2012, 29 May 2012, 11 June 2012. So clearly May was very busy.
Yes.
Up to June, because this is the period when the indictment was being drafted, because the draft indictment was produced on the 12th of June.
Yes.
Yes. And so how would you describe what was going on in those meetings?
No, I had to coordinate, and for me to be able to understand what the case is all about, so that I'm able from time to time to brief the NDPP.
Yes.
Yes.
Because, you know, the accusation, you've heard it, is that if you look at the number of meetings that Advocate Chauke attended, it contradicts his claim that he was not involved in the prosecution decision-making, he was merely coordinating. That's really the case that is being made. What do you say to that?
No, it's relative, Chair. You can't be a coordinator and then you're passive. You sit in your office. You don't really get involved in terms of logistics and understand what these guys they are going through. And in terms of, as you see, some it's about security, some is about the stakeholder engagement, where they would have these differences with the investigation team or the iPad and the like. So I needed to coordinate and do those kind of things.
And you
And
also had
in some of the instances, because of the high-profile nature of the cases, I would attend meetings where they will be being briefed by the investigation teams and the like.
Yes, and you would also need to know something about the merits of the case.
Of course. Yeah, I mean, if you are there, if you are a coordinator, you can't say because I'm a coordinator, I can't listen to say this case is this about and whatever, and this is what we want to do, and this is the evidence and that.
You see, this is where I want to really get your comment on. We have a strange scenario in this case of Advocate Batoyi saying the only thing she ever read about Cato Manu was the report by Advocate Tembeka.
Yes.
Only thing she ever read. She's got no other reference point other than that report.
Yes.
Yet she has made so many significant decisions of withdrawing a case and recommending to the DPP of KZN that against Mr. Boysen, the case must be withdrawn. But the only document she has is that instrument. Now, and I put to her that, look, contrary to what you've done, Advocate Chauke actually has read the material from the dockets. So, although he's a coordinator, but he's steeped in the facts. He knows what's going on in the case. Now, that's where I want...
I'm not so sure if copies would have been made to the...
I thought it had been handed up. It has not been.
No, not that I'm aware.
No, that's fine, don't worry. Perhaps, Madam Chair, could I just ask for leave? It's probably a useful index anyway. It's a list of annexures, and then it's documents considered by Advocate Chauke before the review, post the review, and then in relation to the racketeering, and then it's the documents in relation to the Mulli matter. Do you have it? With
Yes.
you? Oh, yes, wonderful. Thank you.
So what would have seen?
So what page are you at?
It's page 3 of the document.
Yes, thank you.
The first 2 pages is a list of annexures to the statement, to witness statement.
So, sorry, just wait a second. I think the chair wants to.
Yes, this list of annexures is just to help us to locate where these documents are.
Yes.
You already have them in this bundle.
Yes, they're already there. Yes, they're
Just
already
to help
there.
us to locate them.
To locate where they are. Yes.
Yes.
And then, Mr. Chauke, you are where now?
No, I was in page 3 where I said the first 2 pages is the index to the annexures which are part of the statement. So the annexures are there in the statement, but they have not been identified
Yes, that's what the chair wanted to understand. But
Yes.
my question here is this. You have a scenario in which someone in the position of the NDPP says to the panel, the only thing I ever read about this was the Tembeka panel, and makes sweeping decisions about what should happen in the future of the prosecution. Never says, I never opened the docket, don't know anything that's coming from the docket. And that person also says, Mr. Chauke must be charged because in his role as a coordinator or convener or supervisor, he supported the prosecution without evidence. This is an extremely serious charge made by someone who only read the Tembeka report. Now, when you were there at the time, what documents did you yourself personally consider?
That is the one that I'm saying on page 3 on
Yes.
the index. I've listed them.
Yes.
Chair,
All
I can read them quickly.
Yes, please.
On the record.
Yes.
Because I would not even be able to to brief Jiba about this case if all I do is to have documents without reading them.
Yes.
It's monetary awards for both.
Before you proceed,
Yes.
Advocate Chauke, can we give Advocate Jiba her title? She's Advocate Jiba, and the whole day she's been referred to as Jiba. Can
I'm
we-
sorry. I'm sorry. My apologies. My sincere apologies. My sincere apologies, Chair. I've listed them under the heading that documents considered by Advocate Chauke in respect of the racketeering charges. The first one is monetary awards for poison and catamonial unit,
Yes,
with the reference on the record filed in the record as B00017 to B0034. And then the second one is High Court application by Bongani Mkize, DC 00767 to DC 0095.
yes, and that includes its annexures, the whole pleading and
annexes
the
the
court
whole
orders.
yeah.
Yes, thank you.
The third one is meeting on 9 March 2012 with the DPCI at NPS head office. Documents considered, email dated 8 March. This is the meeting that, as referred to, I was called on the 8th, and on the 9th there was a meeting at national office. And then the email that I sent to Jiba to adding the prosecution
Okay,
team.
it's Advocate Chiba. Can I? Sorry.
I'm not sure whether it is easy when people have been working together as colleagues for many years. You may proceed, Advocate
I'm very
Chauke.
sorry. I'm very sorry.
You had us last year cautioning Advocate Batoi.
Indeed.
Yes.
Indeed.
So
My apologies.
you can try. You can try.
Statement of Simpiwe Cyprian Matonti,
Yes.
DC 001,000 to DC 001011.
Yes, we looked at that statement
Yeah.
extensively 2 days ago.
2 days ago, that's the one that I referenced.
Yes, all right. Thank you.
Prosecution team briefing of 24 May 2012, documents considered, memorandum dated 23/12/2012, which is on the record as B00459 to B00462. The other one, I accompanied the prosecution team and the investigation team to Melmont in respect of the Biela matter. This is the matter which was in the front pages of the newspapers.
Yes.
So I went there, accompanied the prosecution team and the investigation team when they went there to see the families and the like. And on the same date, I accompanied the prosecution team and the investigation to Eskaweni in respect of the KwaZulu matter, which was also making high waves about a child who was killed while sleeping with and watching soccer.
Yes, and I mean, the people that have withdrawn these cases have not even been to the families.
I understand so.
Yes.
Okay, Nkabinde,
Yes.
I'm going to request that you pause here.
Yes.
We said that we'll take adjournments after every 1.5 hour.
Indeed.
I think we can take a longer break for some of you who eat dinner before 6 o'clock. You can maybe go and have a snack. I think 30 minutes will be appropriate.
Thank you.
You remember we said you'll work until a little bit late so that you can make good progress. I think it's opportune, Advocate Chauke, to pause for 30 minutes.
Thank you, Chair.
We have asked that they boil water for you to have coffee.
I'm sure we can do that. Would
You
be
are
our
under
supper.
oath, we are adjourned.
Thank you.
That 112, I can't remember what else we were dealing with.
Yes, Madam Chair, I was looking at the documents that the witness had regard to.
Oh, yes.
Yes, from the note that was circulated before we adjourned.
Is the documents considered by Advocate Chauke in respect of the racketeering charges?
In respect of racketeering, yes, Madam Chair.
With a view to brief the NDPP
Yes,
or
yes, with the view, yes, to brief the NDPP and to play his coordinating role.
yes, thank you.
Yes. Thank you, Madam Chair. Mr. Chauke, we are at page 4, just before the draft indictment.
Yes.
Now, the draft indictment is produced sometime in June 2012, correct?
Yes.
In fact, I think that it was circulated to you on the 12th of June.
Yes.
Yes. Now, at that point, I mean, what meetings had you already held, and how were you familiar with the case?
Well, I will not remember how many meetings, but I would have attended the meetings where there was a briefing to the acting NDPP. I think 2 meetings, and then I would have attended, as I indicated, the meeting with the prosecution team, even when they had to prepare the briefing that they will do to the NDPP.
Yes, well, according to this, the substantive meetings you attended would be from on the 3rd of May, 17th of May, 22nd of May, 24th of May, 29th of May. That's 5 meetings.
Yes.
Yes. And then we know that the draft indictment was prepared by Advocate Mayema,
And
Advocate Matendra, and the rest of the prosecution team.
Yes.
Yes. So when it was circulated to you, what was the intention?
The intention was for me to also update and apprise the DPP of KZN.
Yes. I mean, did you regard yourself as being able to comment and say, look, my view is that this particular charge should be phrased differently, or?
No, there was not even a necessity for me to comment then.
Yes, but you had to be sufficiently familiar to play your role.
Yes.
Yes. All right, so we know you had that before it was finalized. There was an issue taken, maybe you can help us with this. There was an issue taken with Advocate Mayema about when, well, it was not taken with Advocate Mayema, it was taken with Mr. Mangena about Advocate Mayema, which is at the time at which the reports were prepared by the ballistics, because they appear to be signed in September 2012. But there already was a draft indictment by the 12th of June. And I couldn't work out what the point of the criticism, whether the point of the criticism was that the prosecutors had decided what the case is and they were just looking for evidence to justify it. I mean, what was your sense as a coordinator?
My sense is that there is a misunderstanding that the signing of the ballistics report should precede the indictment, and which is not accurate, because the Mangena and the investigation team were always meeting with the prosecutors, and they would have drafts of what Mangena says this is what is going to happen. Yes. Remember, in most cases, in majority of cases, the ballistic test results, you require them when you say you want to go on trial, you prepare for trial, then you get that. But in terms of preparations and you always have the drafts which have not necessarily been signed.
I see. So the signing in September has nothing to do with when they are actually prepared?
No.
Yes, all right. So that's just a basic misunderstanding of how the criminal process works.
Precisely.
Yes. Advocate Chauke, would you say that the experts like Mr. Mangena
Yes.
can also be seen as part of the investigation team?
Yes.
Yes, because when you look at the prosecution, normally they guide even the police officer on which way to go and so forth.
Yes.
So he would have been also part of the investigation.
Yes, so if you see in instances where Mr. Mangena and Mr. Stale, they would have sat with the prosecutors and the prosecution team where they were doing the briefings, showing them in respect of this docket, this is the space and whatever. So that does not necessarily mean that he must first go and draft a statement and then come in and say, it doesn't work that way.
Thank you.
Yes, so just, can you repeat your answer? The question is, do you regard the experts like Mr. Mangena and Mr. Stale as part of the as part of the investigative team?
Yeah.
The answer is yes.
Yeah.
All right, thank you. Now, if you turn over then the page to page 5, the small documents there that you had access to and considered.
Yes.
Just take us there.
The statement of Kinkosi Mtian and Ndlondo, this is 00640 to this is 00646. Statement of Colonel Aya, B00926 to B00929, B01266 to B01271.
Yes.
Statement.
Just yes, if you can stop here. You know, there was also another issue taken about the statement of Colonel Aya that was produced on the 31st of August 2012. So the suggestion was, well, how could this statement be taken into account because the indictment was served, the racketeering indictment was served on the 17th of August 2012. You remember that?
Yes.
Yes. And I think it was Mr. Mayema who was challenged with this. And then he says, well, but the information was taken before, although the statement was signed later.
Certainly. You'll see that the other statement is 4 August. The other statement is 31 August.
Yes.
Yeah.
Okay.
But doesn't it happen in a criminal trial or in a criminal case where charges are preferred against someone and the trial commences, yet the investigation continues?
Indeed, Chairperson.
In other words, the investigation never ends.
No.
Until the judge says, this is the pronouncement.
Or until if on the part of the state we say we have closed the case for the state.
Yes, indeed.
Yes.
So you can come up with statements even when the trial has begun,
Yes.
correct?
Yes.
Yes. Does it really stop when the state has closed its case? I thought even when you listen to the version of the other side and there are things to be followed up, you're still entitled to follow those up.
No, I'm talking now in terms of the investigation leading to the trial.
Oh, I see.
At that stage, because that the determination you can only make it after when there is the evidence from the defense, and then that will call for you to respond, and then you'll go and investigate those aspects that you think needs to be. Yeah.
Yes. Okay. And then the statement by Commissioner Brown.
Statement by Commissioner Brown, this same 00945 to this is 00992. This is 00998 to this is 00999. And then statement by Danikas Cross-Bandley, which is in file 1454 to 472.
Yes. Just tell me, I mean, what was your... This statement became a subject of a major controversy, but you know, when the witness finally testified, it's just nothing meaningful was put to him. What was the issue from your understanding at the time about Mr. Danikas?
The signature.
Yes.
Yes. Which was irrelevant in any case, whether the signatures was there or not. But the information about what is it that was being contained in the statement, that's what served before Advocate Jiwa.
Yes.
Yes.
But I mean, what was the prosecution team's strategy around this issue?
The strategy, as I understood it then, because they always, because of Danikas having raised the issue of security and all sort of things, and that, they said they are not going to identify him that is the witness in the case, because that rendered him susceptible to security threats that he has always been sharing with the prosecution team. That's how I understood.
You know, the odd thing about this complaint that Danikas's identity was not disclosed is that if you look at another witness, Mr. Matonsi,
Yes.
whose statement is referred to at page 4 of your list,
Yes.
item 2,
Yes.
you know, it's common cause he was murdered.
Yes.
Yes. And if you also look at page 5, Mr. Begingos Ndlondlo,
Yes.
whose statement is referred to as the first item, it's also common cause he was murdered.
Yes.
You know, and so it makes one wonder why Major General Boysen was so interested in the inclusion of Mr. Danikas in the list of witnesses, when everyone knows that witnesses were killed.
Yeah, the things, as I understand it, which is natural, is once the prosecutor decides to say this witness set danger and to identify him to the defense without just saying, giving a statement and redacting his name and addresses precisely for that purpose. And that is the provision which is there in the Criminal Procedure Act.
Yes, yes. And then the next item is the prosecution memorandum.
Which is at B00993 to B01027. And ballistic reports of Captain Mangena is 2A1 to 2A338 of Captain Mangena's statement.
Yes, why have you not included the ballistics of
Mr. Stale.
Mr. Stale?
At the time when I considered the these ones because this to me the ones that I was submitting when we were doing when we were defending the review application by.
Yes. No, in fact, my junior corrects me that the reports by Mr. Stale were part of the annexures in the Mkiza application.
In the Mkiza application, yeah.
Yes, yes. Yeah. So which actually covers what I was asking you about. Yes. Now, these documents, I mean, they are obviously taken from various parts of the dockets, but they are the key. Are they the key in racketeering?
That's what I'm indicating. That's why even the name there on top, I'm naming them as such. That the heading, the document considered by Advocate Chauke in respect of the racketeering charges.
Yes.
Yes.
And
because this is when we had to defend the review application for certificates to be set aside.
Yes. Now, I mean, understand there are two stages to it. The one is at the time a decision is taken to indict.
Yeah.
So that's all of the things you were looking at in May and in June, where there's a draft indictment right up to the 17th.
Yeah.
Then the indictment is then prepared and served. Right. Now, when was the review brought by Major General Boysen?
You can just help me with the data.
Yes.
Just don't necessarily have the data.
I think it was brought the following year in April 2013. I think we will find it now.
Is it not May 2013?
It could be, Madam Ramakaka.
So somewhere during the start of the year 2013, thereabout.
All right. Turns out my memory isn't that bad. 13th April 2013.
Thank you, Chair.
Yes. I apologize, man. On the Olympics of memory. Yes, so it's brought in April 2013, but I understood that prior to this being brought, there was in fact a request for further particulars.
Yes.
Can you remember that?
It was when the case was transferred from the regional court that was going to be transferred to the High Court.
Yes.
I think when it made appearance there, they filed the request for further particulars, which the prosecution team was responding to the defense and back and forth. And then after the prosecution team, as I understand it, had submitted the further particulars, that's when the accused through the boys and they lodged the review application.
Yes, and the response Mr. Maema spoke about, and I think the document we have it somewhere is about 200 pages long.
Yes.
All of the further
The
particulars.
way he was dealing with the further particulars that were filed.
And then the review was then brought.
Yes.
Now, you remember that one of the issues that are taken, we've now covered what you were looking at prior to the institution until August 2012. Then the review is brought in April 2013. You have to assemble together and defend it. Now, the charges against you here, or the issues to be investigated as per the terms of reference, also criticize you for the role you played in defending the review application.
Yes.
How do you defend yourself there?
The acting NDPP, they had taken a decision that the application for review, even on the advice of the prosecution team, who felt strongly that there was a case. That's what happened.
Yes.
That the defense of that review would never been undertaken if the acting NDPP then would have decided otherwise.
Yes. So the decision to oppose was taken by the acting NDPP.
Yes.
Yes. Well, you know that we looked at the Advocate Maema's delegation of authority,
Yes.
which entrusts him with the authority to oppose not only reviews but appeals,
Yeah.
and also institute
Yes.
reviews and appeals.
Yes.
You know, so he had authority to do it.
Yeah. Well, the application, the notice of motion was against the NDPP.
Yes.
So even if Maema had the delegation to oppose, obviously it would have been with the concurrence of the respondent, who was the NDPP.
Yes. Anyway, your point is that the decision is taken not by you but by the NDPP.
Yes.
Yes. And then what role are you assigned there?
As the coordination, she has to prepare affidavit. She has to file the opposing affidavit, and I got into that, and I advised liaison with Lawrence Odes with all the documents as I listed them here. That which I had to consider, got them from the prosecution team, gave them to advocates Lawrence Odes SC and Advocate Manaka. They drafted, they shared the draft. I shared the draft with the NDPP, corrections here and there, and then take it back and forth and said it. I settled it on her behalf and then sent it to her, and then she signed it.
Yes. I mean, it comes back to the point I asked earlier. I mean, what exactly is Advocate Batoyi expecting would happen? There is a big case launched, and it's against the NDPP. But there are many cases against the NPA. So she has to rationalize her time.
Yeah.
So it's either she attends to this case individually, or she assigns a person that she trusts to look after it. In this case, she asks you.
Indeed.
And what are you expected to do? Just say no.
The expectation with the narrative, as I understood it, it looks like as if when Advocate Chiva in the capacity of NDPP would have delegated people, those was seen to be state capture and whatever. But when the others will do exactly the same thing to delegate is very normal, including herself, Advocate Shamila Batu.
So, so what attaches to this criticism is this notion that, well, the affidavit contained falsehood, mendacity, etc., and you are part and parcel of that. We've looked at that. We've shown that actually the foundation to this entire thing was a flawed foundation.
Indeed.
Yes. Now, before the review, there were certain other, I would say, incidental decisions that you were involved in. Now, there are two that I'm interested in. The one is the centralization. You remember the whole issue that, why is Advocate Chauke signing centralization? And now the reason why centralization became important here is because these Keitomano police followed a man of one of the Ndimande brothers to Rustenburg, and they killed him in his flat. And the question had to be made by the DPP of Northwest, Mr. Smith, to prosecute or not to prosecute. He issued a nolle prosequi, after which it was it rescinded, that nolle prosequi. But then there was a request that all of these must go to KZN, which is where we see your signature there. But can you just explain yourself there?
No, inadvertently, as it were, I should not have signed the application for centralization to Johannesburg using the letterhead of Johannesburg, because that was supposed to be done in the name and direction of the DPP KZN. And once that a mistake was realized, that was where you're talking about recession and whatever, to correct what was supposed to be wrong. And I accepted that one made an omission there, and like it was not supposed to be made by me, because those that were in respect of my jurisdiction, the one which was in Don Park and Jimmy Stan and the like, they were still not added there, and I was not going to have to consent to them, because I was going to consent in respect of those, for them to be centralized in KZN as well.
Yes, no, but can you give just a narrative of what actually happened? So this whole thing happens after the 17th of August 2012.
Yeah. So Advocate Mayema has prepared this draft request, and then he asked me to sign them. Now, when I signed them, I think Advocate Musing or Advocate Smith picked up that the letterhead it's coming from Johannesburg, not necessarily from KZN.
Yeah.
And that's how Advocate Mayema went back to correct that.
Yes, the reason for that is because at the time, Advocate Mayema, according to him, is working in your office.
Yeah, I was sitting in
given them space.
Yeah.
And then what they do is they use your letterhead to type.
To send out correspondences and that, which in this instance of centralization, they couldn't, because in terms of submitting a memorandum or something that the NDPP wanted, it was no issue. I could send it under my letterhead, because it was of no consequence. Yes. But this one, which in terms of statute and the like and jurisdiction, it had to be done under the letterhead of the DPP KZN.
Now, there was some issue raised with the advocate.
Yes. Get there. I'm sorry to do this once you've begun to ask your question. But I just want to clarify, Advocate Chauke, on this issue of centralization. You are speaking about two documents, the one that had been drawn on the letterhead of Gauteng South, and then the subsequent one that was then drawn from the KZN. What you should inform us about is as to on which application of the two, on which application did the NDPP act? Of which one?
I think she acted on the strength of the corrected one. Yes.
Thank you.
Yes. Thank you very much. So there was an issue raised which by the evidence leaders around what is the significance of the signature appearing in a document? Are you taking ownership of it? Are you not taking ownership of it, etc.? That was asked in relation to Mr. Mayema, who says, listen, I drafted the document, but I have no access to the NDPP. The person who has access to the NDPP is Mr. Chauke, and so I'm drafting it in his name, and I'm expecting it to send it on my behalf. And then they look at the memorandum, they say, well, the memorandum doesn't say it is being sent on behalf of Mr. Mayema by Mr. Chauke. So I just want you to take us through how actually you worked with this prosecution team.
Look, let me give you an example. They prepared the presentation, and the presentation must be sent to the NDPP in a meeting that will have arranged, as I indicated. They will give me that presentation. I will send it they will type a letter under my letterhead, and then I'll send the presentation to the NDPP. All right. Now, in terms of the decisions, as it were, once they would have made that decision, the natural thing is suppose that if it's a recommendation about the decision to prosecute, the letterhead that was supposed to be used, the letterhead of the DPP KZN. And which you would have noticed when Mayema testified that he asked me to PP for Advocate Nok. So that is the difference. But in most of the presentations that the meetings that I refer to here, all those presentations I sent them from my office letterhead, because it had nothing to do with that you are recommending a prosecution or not. It was information that had to be conveyed to the NDPP. Yes. Yeah.
I mean, I suppose there was an element of trust as well, that no one will abuse a letterhead of the DPP South Gauteng.
No, of course. These are assistant prosecutors, especially Mayema. Maybe I had this advantage that when I was a senior state advocate in the DPP's office, we were together, the senior state advocates in that office.
Yes. Yeah. So when he puts something in front of you and he says, Mr. Chauke, we've decided as the prosecution team to send this to Advocate Jiba. Yeah. It's not like you sit down and you say, no, I'm questioning you. You sign it, you trust them.
No, really. As colleagues, you start from the question of tapping each other. You can't second guess each other. Yes. If we were to do that, the work strength is going to suffer.
And similarly, when this error was made, it's not as if it's an error that is picked up by a stranger. It's picked up inside the team, and it's internally corrected.
Precisely.
Yes.
And that error, the decision maker did not take issue about it. She understood then that there was error. The NDPP who replaced them, Mr. Ngasana, did not think you have to make a meal out of it. Equally, the Advocate Sean Abrahams did not take issue about it either.
Yes. I mean, I think that there's a difference in somebody picking up later that you made a mistake and you picking up that you've made a mistake and then correcting it on your own.
Yes.
You know, because it's all showing that everyone is acting in good faith.
Of course.
Yes.
Bearing in mind that all these issues we are talking about, insofar as the Katumena matter is concerned, we are dealing with the poker racketeering provisions.
Indeed, Chair.
Even if you signed and you didn't pick up the error, why then does it seem to be an elevation of form over substance? Am I right in thinking that way?
Indeed. That's why I'm trying to explain, to say, look, there were 3 NDPPs, and then 10 years later on, another NDPP says, no, look, this is something. It's done with malice. It's done with all sort of things, and which is just unfortunate.
Because what troubles me, Advocate Chauke is that this case has become such a big case, and yet the terms of reference should be guiding us. You explain in your affidavit from paragraph 6, and you deal with this critical aspect of the terms of reference, a decision.
Yes.
If we find, and I need to be held there, if we find that the terms of reference, insofar as the Katomena matter is concerned, paragraph 3, the entire of paragraph 3, none of those things referred to, the supporting, the recommendation allegedly made by you, the defending of the review application, the appealing against the decision of Governor J, and any attempt to reinstate those charges. If we find that those things, given the fact that these are racketeering issues within the context of poker, doesn't this fall on the wayside?
Indeed, Chair.
If we find that these things don't constitute a decision, a prosecutorial decision, because neither you nor Advocate Mayema or his team could make such decisions, but only the NDPP. So if you find that these alleged conduct on your part do not constitute a decision, what then remains?
What remains there is that there is no basis for the charges as they stood, or the allegations as they stand now.
Because the case has proceeded on the premise, as I understand it, that there was no decision, and I stand to be corrected, Advocate Ngcukaitobi. But then your case went further to gather evidential material to prove that, in fact, there was evidence that justified the institution of the racketeering charges. Is my understanding correct?
Indeed, Chair. My understanding, your understanding is exactly as I understand it, that if there is indeed evidence that there is a case that has been committed, that should be the end of the matter.
So the point is, there is no decision that you have taken, according to you.
Yes.
And if there is no decision, do we even consider the evidential material?
No. To the extent that I accept and I know that I supported the decision, as it were, in terms of me having to send the documents and then prepare these documents to Advocate Jiba and whatever. I'm saying, still that that does not make me a decision maker.
Yes,
Yeah.
that's what I'm trying to probe with you. But I'm saying, once you have crossed that hurdle, the first hurdle of determining whether these things that the terms of reference speak about do not constitute a prosecutorial decision in the context of racketeering charges in terms of poker, then what remains of these claims against you? They have got no merit. And that's why, as advised, that one had to make that point in the opening statement, that you're charging a person who did not make any decision. what then remains is, even if we assume in the favor of the NPA that you participated in a prosecutorial decision,
Yes.
that is, having crossed that first hurdle, the allegation that there was no evidence is flawed.
It's flawed.
Because-
It is without merit.
Yes, because what we have been about was to gather information that says, here is the evidence that justified the institution of the racketeering charges.
Yes.
Is my understanding correct?
That's very correct, Chair.
Advocate Ngcukaitobi, are you helping me to understand
Yes.
how?
Yes.
Because this has been,
No.
I thought that we have so much in front of us, and I'm not sure what we are now pursuing. I thought that we should really focus on the terms of reference.
Yes. No, Madam Chair, you are correct. There's just one issue that Junior wanted to bring to my attention, which to conclude that part about the centralization. It's the document at B01254.
B? B?
At B5.
Is it in the list that you have just submitted to us?
No, apparently not, Madam Chair.
Should it be included? Should it be included?
Yes, I think we should include it
Before post-review period?
before yes, it's 27th August. Yes, it would be before the review period, yes. This page should find here. It's B01254.
I have it, Chair. It's the one that is addressed to from Advocate Musing to Advocate Jiba.
Yes, no, yes, it's relevant in the context of the answer you gave, which was the actual decision maker, who was Advocate Jiba,
Yes.
is the person who was deciding on centralization.
Yeah.
What was going on between the DPPs was which route, it should take. Not that the DPP would decide, but which channel will be followed. Is it the channel of Johannesburg or the channel of KZN?
Yeah. The issue there being that the issue that is being taken there is a consent of the DPP of its jurisdiction is required.
Yes.
So if I'm not the DPP of KZN, I can't issue a consent in respect of.
Yes.
Yeah. So if the offences were committed in Johannesburg and they needed to be tried in KZN, I needed to issue my consent, which must go to the NDPP for the NDPP to issue the centralization.
Yes.
So that is what is being made. That I can't sign a consent to say I consent as the DPP of KZN that the offence committed in KZN should be done in Northwest and vice versa.
Yes, but the point we're making, though, is a slightly different one, which is the decision maker didn't make an issue of the error that had been committed in the previous document.
Exactly.
Yes, and this is what is here.
Yes.
That's where he says, Advocate Musing says, the directive in respect of the above-mentioned provisions have already been approved and signed by you in the above matter in respect of the offences committed within the area of jurisdiction of the DPP Northwest. However, the application was erroneously submitted under cover of a letter from the DPP South Gauteng instead of DPP KZN. A new request has now been submitted under cover of the attached letter from the DPP KZN dated 20 August 2012. It is requested that the acting NDPP issue a new centralization directive as per the attached draft.
Yes.
it is notable that the concern from Advocate Smith SC is directed to the DPP KZN. The facts are otherwise unchanged.
Indeed.
So when you picked up the error internally and you asked the decision maker, here it is, no one said, Mr. Chauke, go to a disciplinary hearing over this.
Yeah.
It's now coming now here that you should be disciplined over this.
Yeah, that's why I'm saying that other than that Advocate Jiba would have accepted that correction. The others who followed her as well did not think that there is anything untoward about that.
All right. Can I ask you? Sorry, finish.
But sitting where I'm sitting now, and the narrative, like indicated, you would have seen once we come into some, when we go some of the opinions, you see there's a specific opinion that is a source of this set capture things, other than the other opinions. And then again, that's where lies the problem.
Well, I mean, there is one opinion that talks about state capture. It's from Advocate Mulli.
Indeed.
Yes. But state capture has become irrelevant, Mr. Chauke, because I asked the NDPP, do you have evidence of state capture? She said no. So let's forget about state capture. It's irrelevant.
I understand, Chair, but unfortunately, I'm sitting here because of state capture.
No, but it's irrelevant. There's no point in you repeating state capture. Because the person who brought the charges, I confronted her, she said no evidence of state capture. So whatever opinions from Mr. Mulli are irrelevant.
I take the point,
Yes,
I take the counsel.
Okay, so no state capture again.
Thank you.
Thank you.
My
very much.
apologies.
Thank you,
My apologies.
Advocate Ngcukaitobi, thank you. I've been resisting the temptation to raise this issue. In every sentence that comes, I say, I hope I'm not going to hear it.
Sorry, Chair.
You
I
have
accept.
understood it, no?
I
Right,
understood.
thank you.
I take the point.
Yes, all right. Now, can I ask you to take your terms of reference again? Let's just do this exercise.
Now that you're going there, where I read and really concerned about counsel, now that you're going there, there's a catch. The catch-all clause there in 3.1. I don't know what you understand that to mean. 3.1 of the terms of reference. Then I'm sure counsel will take you through that so that you can help me. We dealt with this aspect when Advocate Batoyi testified, but was left no wiser. So perhaps we will understand better from you, and further witnesses will come and testify. What did you understand 3.1 to mean?
So if you have, is it easier to get a hard copy? Or
Yes, I actually had it. I don't know. I just misplaced it. I came with 3.1, Chair.
Okay,
You
there's
can look at that hard copy from our researcher.
All right. So it's on page 3 of the terms of reference, and the sentence starts with the fitness of Advocate Chauke to hold office as a prosecutor in the prosecutorial services, in particular in the capacity as a Director of Public Prosecutions, insofar as it relates, 3.1, his direct or indirect conduct of Advocate Chauke relating to his fitness and propriety to hold office based on information, including but not limited to matters related to the following allegations. So I think the question is, what do you understand the direct or indirect conduct relating to your fitness to hold office?
That the conduct, whether I did it directly or indirectly in supporting or otherwise recommending the issuing of the racketeering certificates.
Can I ask you a different question?
Yeah.
What is direct conduct as far as you understand it?
Direct conduct, maybe let me put it this way, that I say physically that here is my view, my recommendation that this should happen. The other one is that which it will be inferred to say, in fact, he did not do it directly. It was done. He used someone to convey this particular message. I'm trying to simplify it in that sense.
But that is also still direct conduct.
Yeah.
Both of those are direct conduct.
I try to make sense and understand what is being conveyed.
And then what is indirect conduct?
I really find it difficult to explain what indirect conduct is, except that, as I say, you would let's take the facts of Catomania in respect of Mr. Boysen, that says he's not on the scene, but is able to drive and direct what should happen at the scene.
No, but that's still direct conduct. He's giving the instructions.
In that. That sense,
I mean, the law usually makes
it's intended to convey an insinuation of malafide.
No, but it's conduct. It's not motive.
Yeah.
Now, because the law usually recognizes either conduct or an omission,
Yeah.
but conduct is conduct. And omission is where there is no conduct, but you should have acted, but you failed to act, and that's where you've omitted.
Yeah.
And there's liability attaching to conduct and liability attaching to omission, where there is a legal duty to act and you fail to act. What is unclear in law is what can indirect conduct be?
I read my understanding there was that the direct and indirect will amount to one and the same thing, but I'm trying to understand and describe it positively as opposed to negatively.
No, but what is the positive description?
That the direct and indirect means one and the same thing.
Yes, all right. But I mean, your statement says these charges are vague and embarrassing.
Indeed, that's what I was trying to indicate in my
And the
opening.
embarrassing part simply means you don't understand what they mean, and therefore you cannot respond to them.
Indeed.
Yes.
So you understand the difference now?
No, I understand the difference. That's why, Chair, I was indicating that to me it would have been one and the same thing, but absent any explanation and about that, I accept that, and on the advice which I accept. That
You align yourself with
Yeah.
that. Yes, thank you.
Yes.
All right. Thank you. And then based on information, and then there's another ambiguity, which is including but not limited. Do you understand what that means? Because if you're going to go to a hearing, you need to know the scope of what is alleged against you. Where does it start? Where does it stop? Now, a phrase like including but not limited seems to imply unlimited liability in time and in scope.
That if I'm sitting here and somebody out there thinks that I must go and say something about Chauke did 15 years or 20 years ago, it should come into this forum. That's I don't say mischief. That's how I see that this is coined to be able to open the wider net. What in criminal prosecutions say, we throw the book at the accused.
Yes. And does that explain why throughout up until now, we still don't know the full scope? Because sometimes you've signed a prosecution, you force someone to sign a prosecution memoranda. Sometimes you force someone to sign a docket. You know. And then sometimes the problem is the centralization. You just never know because these charges are a moving target.
Yeah, at times, the description of when you say you are arranging with the JP, which court, that's a prosecutorial decision.
Yes.
You're deciding to prosecute when you arrange a court.
Yes. And then they keep questioning you about exceeding your jurisdiction, but it's not in the charges.
Yeah.
Because they've done this unlimited scope.
You will understand, as I understood it, that's why there was an attempt to say that the terms of reference must be amended to be in line with what is now being presented.
Well, after cross-examination.
Precisely.
Which is very convenient.
Yeah.
Yes.
Well, if you look at, we dealt with this during the evidence in chief of Advocate Batoyi, because we really wanted to understand what this part of the terms of reference means. I'm looking at the transcript here, where Advocate Batoyi said the following, and you may comment if you wish. Chairperson, if I may at this point explain that paragraph 62.3 refers to taking prosecutorial decision whether to prosecute or not. My evidence will include the fact that a prosecutorial decision is not one that is limited to whether to prosecute or not. Your comment?
Precisely, that's the point that I was trying to make, that it's opening a wider net so that if you can't get this, you should be in a position to rely on this. Because once you say you're talking about organized crime racketeering charges, that wording is actually saying you can also bring any other thing that does not relate to what is in here. And that's why there is an issue of jurisdiction, when in fact that it's not even an issue. But you, as I understood it, the first 5 days or 6 days of the testimony was about jurisdiction.
Yes, but the point is that this answer does not seem to address the fact that we are dealing with racketeering charges here.
Indeed.
It seems to be answering just a general question in a criminal case.
Yeah.
Am I correct?
You are indeed correct.
Further, we referred to Advocate Mlocha's point in his affidavit that he did not want to sign the indictment because he had not been provided with the memo and the dockets.
Yes.
And Advocate Batoyi says, precisely, Chairperson. Then I asked, yes, but that begs the question, does that impact on the terms of reference in relation to Advocate Chauke's direct or indirect alleged indirect conduct? And she answers, Chairperson, if you go to the terms of reference, this aspect of the evidence will relate specifically to, and then let me, if I may explain something. I know I have been asked to keep it short, and I really do, but I want to try to help. I want the panel to understand the circumstances. So these terms of reference were drawn up. It appears that it was taken primarily from my letter that I sent to the President recommending an inquiry to be held. The terms of reference were not discussed with the NPA, but it was taken from there. So we still don't get an answer as to what this part of the terms of reference really means. And when you go back to the question of a decision, prosecutorial decision, I still battle to understand what this aspect covers. And it seems just to be a wide clause, and we have not been presented with evidence, at least so far, that seems to support this allegation under the POCA provisions.
Indeed, it's unfortunate, Chair, that that's what it is. But if one looks at how we understood the process that led to the drafting of this it's confirmed on record that it was drafted after the opinion which was making reference to. I'm no longer going to use that word. In that opinion, there's confirmation that on this terms of reference were settled by Advocate Halu on behalf of the NPA.
Yes.
So my understanding was to try and widen the net, that if we don't get you here, we must get you here.
Yes, I see Advocate Ngcukaitobi tried also to assist there. Can I also assist you? The charge itself limits the factual basis to the finalization of the answering affidavit. It does not include any other thing. Advocate Batoyi, if I may on that point say that I don't know what you say, the chapter on these charges, if you want to call them charges, for want of a better word, states at 3.1 that I've referred to, his direct or indirect conduct should be direct or indirect conduct of Advocate Chauke relating to his fitness and propriety to hold office based on information including but not limited to the matters related to the following allegations. And my point is that in as much as this attempt to set out or do set out conduct of Advocate Chauke in this context, it is not limited to this. So I still don't know what this part of the terms of reference means, and because we have to make an assessment based on this aspect of the charge as well. And probably the evidence leaders will assist us when they call any other witnesses, if there is evidence, to support these very allegations in the terms of reference. Anything else that follows under 3.1, those specific aspects have been addressed. But it is this kind of a catch-all clause in 3.1 that I struggled with. Hence the questions to Advocate Batoyi, but I still find it difficult to understand. Advocate Ngcukaitobi, maybe you'd understand it better.
Yes, well, Madam
If
Chair.
not,
All I can say, Chair, is that I understand, and I look forward to the evidence leaders taking issue with me about that.
yes. Counsel, is your understanding maybe better than my understanding? I struggle with this concept.
Yes. Madam Chair, the only thing I was going to suggest is the actual cross-examination on this point is illuminating. I hadn't actually realized that it's as useful as it is. Now, because what let me just go to, I think it's day 14. Yes. What page? At page 48. Where does it start? The first question.
The 8th of December 2025.
Yes, Madam Chair. Yes, at day 14. So if we go to at the bottom of that page, so it's line 20. Yes. So I asked Advocate Batoyi, well, this is what I'm debating with you, Advocate Batoy. What is the indirect conduct that is referenced? So that was the question. She then says, so I need to think about all of the evidence that I have provided thus far. So I then continue. But I'm asking you, I'm putting to you that the charge 3.1.1.3, you are saying the answer to me, no, look at the indirect evidence. And I'm asking you, what is the indirect evidence? She then says, with all due respect, I did not say look at the indirect evidence. What I said is that I was reading out the chapeau, that's like the introduction. And I said it states including but not limited to matters relating to the following allegations. My point being not about indirect conduct, but about the fact that the allegations are not limited to what is set out in 3.11 until 3.115. That was the point. Then I say, now, what are the other allegations that are not included? What do we not have? Then she says, well, for example, the allegations relating to the signing of the Advocate Chauke's request for Advocate Mlocho to sign the indictment. I said, no, please. Then she says, that should have been included here. I said, please, Advocate Batoy, we are at 3.1.13. At the stage at which Major General Boyson is in court, the NDPP is filing an answering affidavit. The charge tells us that its scope is the finalization of the answering affidavit. You are resisting my submission to you that the scope is limited. You are saying it is unlimited. I'm asking you, what are the other facts that support the defense of that review application? And then she says, I do not know if there are any other facts. That's why. So where we ended the discussion is when she said she just didn't know herself. So I don't think anyone will ever know. And because the first witness of the evidence leaders is Major General Boyson, I don't think she'll educate us more about the terms of reference.
May I just come in here? Advocate Chauke, when much as at the end they have that, a catch-all phrase where it's clear that the list is not closed. But if we are to focus on the reason for Advocate Mlocho's refusal to sign the document, it is quite clear, and it's a closed list. Ne? And it says Advocate Mlocho refused to sign the letter in the absence of only two or either of the two. And that is either the prosecution memorandum or the original case dockets. So as far as that requirement of the signing or the reasons for not signing, we have a clear enclosed answer. It's not an open-ended answer that we get. Are we in agreement about that?
Yes.
Right, thank you. Thanks.
Thank you. If we then proceed from there, 3.1.1 talks about the institution of the racketeering charges in terms of Section 2, Section 4 of POCA against Major General Boyson and members of the Kaitomano unit and the defense of those actions in subsequent review proceedings brought by Major General Boyson to have the racketeering certificates set aside. Now, the institution of the racketeering charges, whose decision is that?
It's the NDPP.
Now, and then the defense of those actions, I presume this means the review in court. Whose decision was that?
The NDPP.
Yes. Now, then they try and set this out. 3.1.1.1 supported a decision to prosecute the accused, notwithstanding that there was no evidence justifying the decision. And he sought to improperly have the acting Director of Public Prosecutions to sign the case dockets and or prosecution memorandum detailing the alleged evidence implicating the accused on which the decision to indict had to be made. So if we look at the first one, the evidence of Mr. Mayema is that he is the one who recommended the decision. And in fact, he goes further, he says, it's not Advocate Chauke. And you know the interesting thing is that he is never cross-examined on that point. What is your testimony on this supporting a decision?
Like Advocate Mayema indicated, I would, in the coordinating role, be able to understand this is the case all about. But
No, Mr. Chauke, what is your evidence on whether you supported the decision or not in the light of the evidence of Mr. Mayema?
I did not. The person who supported is Advocate Mayema on behalf of with the prosecution team.
Yes. Now, then there is another issue here. You sought improperly to have, that's Mr. Mlocho, sign case dockets. Did this happen?
No.
Then there's another thing here that you sought improperly to have Mr. Mlocho to sign a prosecution memorandum. Did this happen?
No.
You know, the oddity about this is that Mr. Mlocho's email says he never got the prosecution memorandum. Now you have a charge that says you tried to force him to sign it.
Remember, the discussion between me and Mlocho is about him signing the indictment, not what is being set out here.
Yes, but I'm saying that he said he didn't have it.
Yes.
The charge is that you said he must sign it.
Yeah.
But how does he sign a document that he doesn't have?
Precisely.
Yes.
Because in terms of that email, is that he was requesting me that I must provide him with a
Yes.
prosecution memorandum.
Then you are being charged for saying he must sign it.
He must sign the prosecution memorandum.
Now, they tried to change this through the evidence of Advocate Batoyi. They said you tried to say he must sign an indictment.
Yes.
But then it fell apart when Advocate Mutsweni withdrew the question.
Yeah.
Yes.
That's when the testimony of Advocate Mayema.
Yes. Now, then 3.1.1.2, you recommended to the then acting National Director of Public Prosecutions, Advocate Jiba, the application for issuing a racketeering authorization in terms of Section 2, subsection 4, whereas there was no evidence justifying the institution of racketeering charges. Now, what's your evidence on this? Again, in the light of what Advocate Mayema said.
The prosecution team recommended the application, and I forwarded that recommendation to the.
You know, the strange thing is that Advocate Mayema said that and then was not cross-examined on this. Yes. Now, then there is this thing about no evidence justifying the institution. I mean, is there any person who is reasonable in their head who can say, after having listened to the 3 months of evidence, that there is no evidence for the justification of the prosecution?
Chair, what I could read from this is that the people, Special Advocate Batoyi and others, they did not necessarily read the actual evidence.
Yes.
They relied on what somebody would have told them. Because if they themselves had taken the time to go through the statements or the dockets, even 1 or 2 dockets, they would have realized that this assertion is not necessarily stand the scrutiny of justification.
So there's no reasonable person who can say there's no evidence.
No, not at all.
Because we are told that there's Mr. Major General Boyson is coming to give evidence apparently for 8 days. Now, what is the relevance of a witness who's an accused in a decision, making a prosecution decision?
I'm surprised, and the majority of the NPA prosecutors, most of them, they're asking to say, what is it that the NPA goes out of its way to defend an accused person?
Yes.
It's really the prosecutors. Most of the people who understand what we do as prosecutors, they are surprised. What is it that is in this so-called Katomania case that the NPA goes out to defend an accused person?
Yes, but isn't it something beyond that? It is the NPA relies on its case on a person who is an accused, who was an accused.
Precisely. As if he was going to say, you charged me correctly, please prosecute me.
Yes. But if you were to make a decision to charge a person, I don't understand. Would you go and ask them, are you guilty or innocent?
This is what the NDPP has done.
Yes. No, I think we can't tell that. Yes. You see, because that's what I really just struggle to understand, is that if every potential criminal in this country was asked by the NPA, go to an inquiry and say you are not guilty, where would the NPA be?
Worse still, it's how many cases are we charging people, and then they go to court, they get acquitted, or they go to court, they on review, they succeed.
Yes.
Why have those not been complained of, and then inquiries in respect of those prosecutors or DPPs instituted?
Yeah, well,
there is something in this one, there is something more than what it's being presented here.
Yes.
But if that
Unfortunately.
happens, that will have a chilling effect
Indeed.
on the prosecutorial discretion.
Indeed. And prosecutors, some of them, they're even afraid to make decisions now against the background of what's happening. That it looks like when you make a decision that is not in accord with the current leadership, then you are likely to go through a misconduct. And it's problematic because that is no longer prosecutors exercising prosecutorial decision without fear, favor, or prejudice.
Yes. Now,
At least here, you have told us, and we are yet to hear further evidence. You have told us that you did not make any prosecutorial decision.
Indeed.
And Advocate Maema, as evidence, corroborates that. Am I correct?
Indeed.
thank you, Madam Chair. Then,
Just,
yes.
yeah, we're talking about the prosecution and responsibilities and obligations.
Yes.
Now, Advocate Batohi told us that a DPP has a duty to prosecute if there is a prima facie case and if there is no compelling reason for a refusal to prosecute. Now, this duty, is it correct to say that duty also lies with the NDPP?
Precisely. And the scale is even higher than when you refer to an ordinary prosecutor.
Okay. Now, looking at the facts and the evidence that is before this panel thus far, would you say that there is prima facie case on which these cases complained of should have been prosecuted? And I'm asking this in particular with reference to the Poisons case. Now,
There is overwhelming prima facie case against General Poison and members of the Katomeni.
Advocate Chauke, you're teaching me something. Overwhelming prima facie. Okay, if for the purposes of this inquiry, maybe one should adopt that. Now, if there is overwhelming prima facie, or rather, let's drop that overwhelming out of the engagement. If there is prima facie case or prima facie evidence, would it be proper for the NPA, and when I'm talking about the NPA, I'm talking about the entire prosecution,
Yes.
be it at a provincial level or what, would it be proper then not to prosecute the case if there is prima facie case?
No, it's very improper. It's not in the interest of justice. Once you get to a prima facie case, it says you should prosecute unless if evidence when you have made that decision comes to the fore, that indicates that your prima facie case is no longer sustainable and the like, and that's why you have to reconsider decisions as and when you proceed.
But in her case, she actually explained that unless there are compelling reasons for refusal to prosecute, And I remember talking about in cases like where maybe the parent has
An
knocked
accident,
out-
where
accident
a
and so
parent will
forth.
have run over a child
Exactly.
when she's reversing
Yeah,
a car.
those are examples that she gave. But in this case that we are now talking about, especially with regard to the poisons case, are there any compelling reasons that you are aware of that have been advanced for the decision of the NDPP to then withdraw the charges against the General Poisons and co-accused?
I'm not aware of any. In fact, I have not seen, even on record, where General Poison has made written representations to the NDPP for her to consider this matter.
Who bears the onus to show that there are compelling reasons for this position to be taken, a position to withdraw or not to proceed with the matter?
The accused persons through representations.
Thank you, sir. Thank you.
Thank you, Madam Makgakga. Now, so we've dealt with 3.1.1, 3.1.1.2. 3.1.1.3. Now, it's talking about you sought to defend the institution in the review proceedings brought by Major General Boyce. Now, who took the decision to defend the case?
The acting NDPP, Advocate Jiva.
Yes. And then you finalized the answering affidavit of the then acting National Director of Public Prosecution in the poison review proceedings in opposing the review application, notwithstanding that there was no evidence justifying the institution of racketeering charges against the accused. Now, the case here, it seems to be that you defended the decision by assisting the NDPP to prepare an answering affidavit. Can you just explain that?
No, the counsel appointed in the matter is Advocate SC and Advocate Manaka. They prepare the opposition to the application, discuss it, show it to Jiba. Jiba says no, help finalize it with the legal team for us to be able to say this, and I get into the nick of things. I sit with the council. They send me. I send my comments and the like, and then I send it to Advocate Jiwa. I say I'm satisfied. This is what is coming from council, and it's in accord with what has been presented to you for the decision that you have made, which is now being challenged. And she was happy. She signed the.
You know, the problem is, you see, whenever you see something called misconduct, it's usually deviation from expected standard or expected conduct. What I can't work out here is what were you expected to do? There is a case brought against the NDPP. The person cited nominally is the NDPP. She then says, Mr. Chauke, please assist me to draft the application, to draft the answering affidavit, which you then do with the advocates on the brief. What on earth are they saying you should have done?
It's because it's Jiba. You should not have done it.
No, but I'm saying from your perspective, what were you expected to do? What is the expected conduct when your boss says, help me to draft an answering affidavit?
I must refuse and say, no, I can't do it.
But I mean, is that a sensible thing?
Of course, it's nonsensical, to say the least. There's no justification for that, and I can't. It's a colleague to my supervisor. She's asking for assistance within, which is lawful, and then within my work environment, and they're like, how do you do that?
Yes.
I can tell you now that even in the past 7 years that Advocate Shamila Bato has been here, she has never finalized the the affidavits and all those things by herself without anyone assisting her. It just doesn't work that way.
Yes. And then the only way then to justify this charge is this catch-all, no evidence.
Yeah,
But as soon as you cross that line, that's the end of this charge.
indeed.
Yes.
Yeah, Advocate. Still on this issue of the counsel that were appointed to deal with this matter, to oppose the review application. The brief to counsel, who issued the brief to counsel? Is it the office of the NDPP or is it the office of the
State attorney.
DPP?
No, it will be the office of the NDPP through the state attorney.
And that makes it clear as to who is actually opposing the review application.
Indeed.
Thank you.
Yes. Thank you. And then 3.1.1.4 says you instituted an appeal against the judgment of Judge Govan without the approval of the then National Director of Public Prosecutions, Mr. Mulli. We've dealt with the catch-all, no evidence. But I just want to get the facts straight around how this appeal story unfold.
What had happened? It's a decision that the Govan J has made. It's given to the prosecutors to say this is what this is happening. The prosecutors looked at the decision, and then they said, no, look, in view of this, we cannot appeal because we are being told that there is a concession that was made by Mr. Hodes. They sent me that view of them. I take that view, I send it to Mr. Lawrence Hodes to say this is the view of the prosecution team. What is your view? And Lawrence Hodes says, no, look, let's have a meeting with the prosecution team because there is nothing like that I had considered. And now, Advocate Mayema, the lead prosecutor, like he indicated, after the discussions with counsel, it was decided no, an approach must be made for the NDPP to file to appeal this ruling by Govan J. Now the dias is running, and I was requested to brief Advocate Dr. Ramaite to say this. We have got this scenario. Can we get the approval from the NDPP for the latter to authorize the filing of the appeal? Of course, it was taking some time that Advocate Ramaite did not come back to me to confirm whether and then the dice was running. And counsel advised to say, look, what we should do is we can file provisionally so that we don't have to do condemnations and all sort of things. And then again, the event that the NDPP approves, then we'll proceed. If he withdraws, then he will withdraw. And then, indeed, that's what has happened. But unfortunately, Advocate Dr. Ramaite omitted to timelessly brief the NDPP, and it came out in the press. And then Mr. Ngasana saw it in the press that the NDPP NPA is appealing the Govan judgment. Of course, he became unhappy and not appreciating that this kind of a decision would have been taken without his knowledge or approval. Consequence to that, we were called to a meeting between me, the I think it was Advocate Mayema, and Matenjwa, and the NDPP with his advisors and Dr. Ramaite. And in that meeting, Dr. Amaete acknowledged to say, apologized to say, no, look, indeed I was I advised that I should brief you timeously with the documents to say this is what should happen in view of the government judgment and the like. Of course, Mr. Ngasana then indicated his unhappiness about that, and then he said he accepts the apology from Dr. Amaete, but he has decided that there should not be an appeal, and then instructed me that I should inform the state attorney to withdraw the appeal accordingly. And that's exactly what I did. After the meeting, I sent the email to the state attorney to say the NDPP has decided not to appeal, and that the appeal should be withdrawn.
You see, because Mr. Maema confirmed exactly what you're saying, that actually the decision was that of the prosecution team.
Yeah.
And it had to be filed with some urgency because of the time limits.
Yeah.
And then when it was decided not to proceed with it, it was withdrawn.
Yeah.
But more importantly, for your purposes, the person who you would have undermined, quote unquote, by appealing without their consent is Mr. Ngasana.
Yeah.
What was his view about this? Did he think, well, this is now a big misconduct charge, I should now go after?
No, you would know if needs be, probably, if time allows, he will come and testify, or he will send a statement to indicate that he is even surprised that that has been made to be a charge which relates to him, and this was not even discussed with him.
Yes.
I can say for a fact that he's surprised, even as I'm sitting here, he's surprised that there is that kind of a charge that relates to him, and he has never even been consulted.
Yes. I mean, if he thought there was a misconduct problem, he would have instituted charges back then in 2012.
Indeed.
Through you, does this now suggest that Advocate Ngasana is the appropriate person to can talk about whether it was you in some way or the other constituted misconduct, or your actions constituted misconduct by pursuing the
Appeal.
or instituting the notice of appeal? It was not even pursuing the appeal, but instituting that notice of appeal.
No, indeed, Chair. That's what I'm saying, as a matter of fact, because when he saw this, and when I approached him, then he was surprised, and then he said, "How can the NPA and the DPP do something like this without even consulting me?" As if I am the one who's complaining that this is what Chauke and the prosecutor's team have done.
Yes. And then it's the usual story, no charges. Well, no justification for the charges. And then the last one under Keitoman is attempted to have racketeering charges against Major General Boyson and members of the Keitoman unit reinstated by the then National Director of Public Prosecution, Mr. Ngasana. So let's just stop there. What does this mean, that you attempted to have these charges reinstated?
Chair, on the record, what has happened after when that meeting that I referred to, where Ngasana issued an instruction to withdraw the appeal, he immediately set up a date to say he wants to have a full briefing of the matter, because he did not have the background and all sort of things and the like. And the matter, the date was arranged, I think the 20. I'll get the actual date on the statement, but it was, I think, 7 days or 14 days after the date when we met about him withdrawing the appeal. And in that meeting, the prosecution team, Mayema and Matenja, they were doing the presentation. In that meeting, Advocate Nogo was also invited to be present in that meeting. And that's where in that meeting where he said, okay, I understand, you guys go and find more, because the the judgment does not say we cannot reissue this statement. And he made even reference also to a signed statement of Danikas, and they like to say once you are ready and have got more, bring the application. I will consider it. I understand that meeting is the one that is said to be an influence for him to consider a reissuing of this of the racketeering. Other than that, where it's coming from, I really do not know. But I can tell you now that Mr. Ngasana is also surprised that there is this allegation that there was an attempt, a subtle attempt, or with a malafide that he was supposed to issue a racketeering certificate, which is not.
The actual evidence we have so far, even if you forget about Mr. Ngasana for a moment, is from Mr. Mayema, who says that his view remained throughout the tenure of Mr. Ngasana and the tenure of Mr. Abrams, that these charges should never have been withdrawn. They should be reinstated.
Yes.
And he motivated to Mr. Ngasana to reinstate the charges.
Yes.
And Mr. Ngasana felt that there were certain evidentiary gaps to be filled.
Yeah. But when that motivation was done, the second motivation, I was not there. The meeting that I attended,
Yes.
in which Ngasana said, no, from now on, Chauke, because Noko is not as conflicted as a predecessor, you must now stop being the coordinator. Noko should,
Yes. And that
should
was
take
in
off.
April 2014.
Yeah, that's when that was the period of that, the appeal and what have you.
Yes.
So like Advocate Mahema said, he did this presentation and then he was, they were told to go and find more. They went to go and find more, and then they did the presentation to Mr. Ngasana, but he was still not satisfied. He had all those queries and whatever. So the reality is, Advocate Mahema would have been the one who would have went back to consider that this the case should be re-enrolled and the like.
Yes. Well, I mean,
Just coming in here, that portion of the evidence, it is correct that also Advocate Ngasana,
Yes.
I beg your pardon, attorney
Mr. Ngasana.
Yes, Mr. Ngasana. Mr. Ngasana made it clear at some point that he is conflicted.
Yes.
And that could have been also part of the delay. He's conflicted in respect of the Katomena case.
Yeah, he said
because of his relationship.
Yeah, he said to some of whether were the victims of the accused that he would have they would have been his client or something to that effect. But like Advocate Mahema had explained, there was something like that, and then he had indicated ultimately I might have to delegate the issuing, the authorization of this to one of my deputies.
Yes, but I'm just saying the reason advanced according to the evidence that is now on record is that he had a relationship, be it business relationship, working relationship, whatever, but the relationship with some of the Katomena officials.
Yeah, some of
unit
the West clients, I cannot
That's
remember
right.
whether it was the officers or the victims in respect of, but something to that effect.
Okay, thank you.
thank you.
Okay, Ngcukaitobi, I know that you have now exhausted the terms and the
Katomena.
rubric of
Yes.
Katomena matter.
Yes.
Shouldn't we pause here? It's 7:55. It's late
Indeed.
in the hour. We are not going to sleep here. I hope I didn't interrupt your
No, this is the right time.
clarification. I think we should pause Advocate Chauke until tomorrow morning at 9 o'clock.
Thank you, Chair.
And I suppose, Advocate Ngcukaitobi, we will run to finish with the witness tomorrow.
Madam Chair, I think we've done 60% of the job today, so we could even have a short day tomorrow.
Can I rely on that undertaking?
No, I don't rely. No more public undertakings.
Yes, thank you very much. Sorry we kept you until late in the hour, but we have made some progress. Advocate Chauke, you remain under oath, and you will continue tomorrow morning at 9 o'clock.
Thank you, Chair. I do
Thank you.
confirm.
We'll adjourn.